Lordship's kind permission. But yesterday I mentioned I'll give a chart. I just prepared it for your Lordship's convenience, severable, non-severable. And maybe after the others finish, I can just explain it.
Yes, please.
Yes. I made severable, non-severable, then within sub-parts. But I'll explain it after the others finish.
Something all part of your argument.
Pardon me?
All part of your
No,
argument.
I just want a chart, so easy to follow, not so that's why.
I catch up.
No, the only thing is, in 34.4, we have not addressed the meaning of the word appropriate. I don't want to interrupt others because when I come, the 34.4 as the word appropriate, it's not necessary, it has to be sent back. The court may find it inappropriate, the court may decide itself. That point I'll clarify later.
Yes, please.
Please, my lords. I want to repeat what has already been argued previously. Just run through it quickly. I think your lordships have already heard enough of us. We have an opportunity right now to really set right a problem which we've been plaguing us for the last 20 years. Litigants being run between court to tribunal and vice versa. Or do we dig ourselves our heels inside and say, sorry, there's nothing that we can do. This is how the system is. We submit it's the former. That is an imaginary problem. Section 5 is not really a valid answer to the problem. Section 5 is actually a gateway, not an obstacle. Section 5 permits a Section 34 court to intervene in any manner it wishes to once the gateway is open. Because Section 5, the last part of Section 5 reads that the court may intervene where so provided. It doesn't say in the manner so provided. The reading of Section 5 is only a gateway to get inside. And once that opportunity is there, whatever powers the court wishes to apply are available to it. It appears at the end of Section 5, my lord. The second is, to what extent should there be corrections permitted to an arbitration award? And we submit, and this is a very important aspect because if your lordship's hold is it should not be done too widely because we'll have another problem being opened. We submit it should be restricted to certain aspects only. Number one is when there is a non-discretionary aspect, that is either there is a statutory right or a contractual right. One. Two is if it is a matter of modification of an interest. And three, if there's any calculation related errors. Now, it is why this is so important is because it leads to the entire concept of enforcement of rights, what a statute provides. If the tribunal is not either rightly or wrongly ordering that, awarding that, if a court does not correct that, it puts a big question mark on ease of enforcement of contracts, on the rule of law that we're enjoying. Because then the moment you see litigation dragging on, somebody going from court to tribunal, it casts a question on our ease of doing business in India, which is why there must be certainty, finality, and efficiency in the entire process. Therefore, these are from a policy perspective. I think the legal points have already been very adequately covered by my learned seniors. Now, we've tendered a note. In that note, my lord, we've already dealt with the series of judgments which already my learned colleagues have dealt with as to where the court has previously interfered with awards. The only relevant one I want to show, my lord, is the Hindustan Zinc versus French coal carbonization. In that, the Section 34 judge modified an award. A Section 37 judge, the 2006 4 SEC, the Section 37 judge set aside the Section 34 order on the basis that it should not have been modified with. The Supreme Court said
Page number.
2006 4 SEC 445.
2006.
2006 4 SEC 445. Hindustan Zinc versus French coal carbonization, where the Supreme Court upheld the Section 34 order allowing the modification. And that is the correct system we submit that must be followed.
But what was the modification made? What was the modification made?
That was on the main merits of the matter it had gone on to, on the calculation of the damages.
Computation of damages. Where is the reasoning given? But without reason, they just applied.
Para 25, 24 onwards. The basis of the calculations.
It is on the basis of calculation.
Last line, the order of the division bench is unsustainable as it fails to interfere with a portion of the award which is opposed to the specific terms of the contract On the other hand, the trial court had correctly decided the matter. So in that category of if it is a contractual right, statutory right, interference must be there. If it is calculation of an error,
Statutory
interference
right, then you're rewriting the award.
only to this limited extent where there is no discretion.
That, no. When
Yes, madam.
say in a contract says no escalation, come what may,
Then there is no discretion.
even if we extend the time, arbitrators normally find a way to get over these clauses.
Correct.
Because in equity, these clauses are one-sided, completely one-sided. There's a direct form contract.
So if the court feels that
If we do that, then virtually we'll be rewriting the award.
So just to correct, rewriting the award to a limited extent is not a bad thing. Rewriting the award because if one follows a policy that no rewriting is the policy which is being advised by the other side and is the one that is causing the problem. So partial rewriting in these limited circumstances should be permitted for a systemic benefit is what our submission is. So if there is a discretion to the tribunal, then court should not interfere. But if there's no discretion, if there's a contractual right, statutory right, then the court must interfere in those cases. We have to lay down limits.
Will setting aside include that part?
So that point has already been adequately addressed. So setting aside includes that limited right of modification and modification not quite, but with this limited aspect, my lord. Main point is the huge expense, effort that parties have undertaken.
Okay,
to be
fine.
nipped into
That's
the
all.
bud. Just 2-3 more points, my lord. There's another risk of this section 34(4) I'll just address. Is this if a court refers it back to the tribunal and tribunal maintains its view, this is a risk of an infinite bounce. It will come back in a 34 may again hold its view. It's again a never-ending process, litigant suffering right throughout. Again on 34(4).
So already argued so many times.
I'll just make 2 more points. 34(4), 90% of the entire work is already been completed. Why not just finish it instead of sending them back all the way to this? And at many times, the lordship should have seen tribunal is no more available either because of age or retirement. So a lot of practical difficulties are there in referring matters back to tribunal. So it is best from a commercial as well as practical and legal that the matter be closed at that stage. So we've seen international statutes. They provide for the power to modify. We've seen US, Singapore, Australia, England. The only one that prohibits is in Singapore in the context of international arbitration. In our case, we have a clean slate. So we have the opportunity to set right what we think is correct. And that is what we submit should be done. The statutes are already provided by Mr. Mehta in his written note. I'm grateful to my lords.
Please call out the name.
Please, Lords, while adopting the submissions of my erudite senior colleagues, my lords, on the reason why lordship should in fact permit modification of awards, I want to focus on a very limited aspect. Lordship's repeated query during the course of this hearing has been, if we agree that this power is there, what is the Lakshman Rekha that we will draw for identifying the scenarios and the benchmark when this power should be exercised? So, my lord, I am only arguing on that issue because of the limited time available with me. Lordships may kindly have my written submissions, paragraph 4, where I have sought to encapsulate 3 scenarios where the Honorable Court may consider exercise of this limited power of modification. If Lordships would be so kind, my lord, to have my written submissions, if all the Honorable Judges have it, my lords, may I just place that?
Yes.
My lords, I am just requesting my lords to have with me paragraph 4 of my written submissions. I've also handed over extra copies, my lords, so any honorable member of the bench, I would deeply obliged. My lords, may I place paragraph 4, just the initial portion. Various scenarios would arise where the interest of justice, as also institutional effectiveness of arbitration as a form of alternative dispute resolution, would be better subserved if courts can modify an award without relegating the parties to a second round of arbitration, provided that such a modification would not require a detailed inquiry into the facts of the case. Now, please see 3 scenarios, my lords. For instance, in one scenario, scenario 1, an arbitral tribunal may deny interest on the claims in toto. However, if the court determines in a section 34 or 37 proceeding that interest was unjustly denied, the court should have the power to modify the award and grant a reasonable rate of interest without relegating the parties to a fresh round of arbitration on this sole aspect. In another scenario, scenario 2, if the court determines that the interest granted by the tribunal is unsustainably high or low, the court should have the power to reduce or increase the interest rate without having to remand the parties to a fresh arbitration with regard to rate of interest. Now, these two, my lords, are relatively low-hanging fruit. Now, please see the more controversial scenario 3. There might arise a third scenario, scenario 3, where the findings of the arbitral tribunal might be ex facie contrary to the record of the tribunal or the agreement between the parties, and modifying the award would not require an elaborate inquiry into the materials already placed before the arbitrator. Now, my lord, for this third scenario, I wish to place before my lord a judgment of the division bench of the Honorable Delhi High Court, which would show to my lord exactly why this limited curated power should be available. My lord, please have my judgment compilation. There are many judgments there. I'm only going to show lordships 2 of them because of the limited time that I have at my disposal. Please see this judgment, which is at serial number 1, page 1, IRB Infra. My lord, this is a new judgment compilation that's been handed over. I have removed my earlier one because most of it was already covered. This is, my lord, running into 79 pages. I hope lordships has this judgment compilation.
Yes.
Yes, lordships may just see the first judgment of the division bench in IRB Ahmedabad versus NHAI. My lord, the facts were interesting. The contractor in this case files a claim, which lordships will find at paragraph 4 at page 2, seeking an award that it is entitled to issue passes without offering discounts to local commuters on the highway. So the majority award finds that yes, you are entitled, you don't need to give a discount to the local commuters. Now the NHAI filed a counterclaim, which I'll take lordships to, which said no, direct them that they must provide the discount. Now in the section 34, the single judge sets aside the award. The contractor appeals to the division bench. The division bench upholds the single judge's order, but now please see what the honorable division bench does. So lordships will now note this interesting formulation. Please have with me, my lords, paragraph 36 at page 15. This is a perfect example of scenario 3. Please see para 36 minutes at page 15. May I read, my lords?
Yes.
Before the arbitrator, the NHAI had filed counterclaims and prayed as under. In view of submissions made above, the claims of the claimant may be rejected and the claimant be directed to. Now, please note, my lords, Roman serial 1 and 2 are precisely the counter to the claim, which is direct them to issue discounted passes. Now, my lord, please see para 37. That's pregnant with legal consequence. The arbitrators in the award did not go into the counterclaims of NHAI, but granted the claims of appellant. Since the stand of the appellant has been rejected and award has been set aside, it is directed that the NHAI shall ensure that the concessional passes, discounts and exemptions as per notified toll rates are being extended to commuters and users. The appellant shall submit all its accounts within 8 weeks, who shall be entitled to recover all the excess amounts charged by the appellant. Now, my lord, the unarticulated premise of what the honorable division bench says is, it's a useless formality now to send the NHAI back to a fresh arbitration to again agitate its counterclaims, because the courts applied its mind and the courts found that the stand of the contractor is completely unsustainable. Now, in a situation like this, my lords, will the courts now relegate the parties back to a fresh arbitration for something that's ex facie clear? Now, my lord, one question which will come is, all right, this is one factual scenario. How do we lay down a test? Now, my lord, with my limited understanding, my respectful submission is, and I say it with all responsibility at my command, useless formality. Useless formality is a controversial doctrine in administrative law. Because lordships knows in administrative law, there is this dichotomy between the principles of natural justice not being applied and admitted facts leading to a particular conclusion. So that's a controversial doctrine in administrative law and service law. But please see, my lord, if we remove that element of natural justice, which would not arise here, please see one formulation which I can commend for lordship's kind acceptance. Please see page 56 of my judgment compilation, which is, my lords, part of the judgment of this honorable court in MC Mehta, which begins at page 49. Please have, my lords, page 56. Please have with me para 21. Now, this is in the context of useless formality in administrative/service law, but please see para 21. Now, lordships may ignore the first words beginning with, it is therefore clear that. Please start with, if on the admitted. Please note this, my lords. Lordships has that, my lords. At para 21 at page 56, my lords.
Yes.
At 21, please ignore the initial words. It is therefore clear that now, my lord, please mark from here, if lordship would be so kind. If on the admitted or indisputable factual position, only one conclusion is possible and permissible, full stop. In my respectful submission, for determining scenario 3, this strict test lordships would consider employing, because in my respectful submission, and I will just end with that, arbitration is a chameleon. Lordship saw the judgment in IRB. Even though arbitrations are ultimately private contracts, in many ways, they overlap and interface with issues that affect the larger legal system. And my lord, these are not my words. Please therefore permit me to conclude with just one more reference. Lordships may have, my lords, in my judgment compilation, the article, my lords, at page 59. Now, this is, my lords, a 1952 article, which is considered the most unadulterated normative exposition of arbitration because of the genre and the era in which it arose, relatively uninfluenced by the commercial explosion that's happened thereafter. Now, my lord, this article, my lord, lordships may kindly see at page 59. And my lord, I will just take lordships to page 63. We think arbitration, we fetishize arbitration today as purely being this commercial agreement between two parties. But arbitration goes beyond that. Why does it do so? Please see page 63.
Yes.
Lordships may note the 5 components of arbitration. I will trouble my lords with A, B, and E. Please let me start with A. Arbitration as a creature of the parties. My lords has that, my lords, at 63. May I read?
Yes, please.
Yes. The statement that arbitration is a creature of the parties, that its occurrence, form, and scope are dependent on the will and consent of parties is but part of the truth. Although the arbitration agreement, as any agreement, is consensual within its limited compass, it is also in varying degree depending on the law of the particular jurisdiction. Now, please note, my lord, a delegation of the power of the state to private parties for their private ends. That delegation proceeds on the assumption that the attainment of those ends will also subserve public interest with a sufficiently high degree or incidence to justify such delegation. The basic assumption is, as we pointed out in the preceding section, that arbitration is an allowable extension of the sphere of contract, yet the fact that it is consensual profoundly affects the nature of the award and the value sought to be served by the award, and hence the determination at the ends of the attainment of which the power of the state will be brought to bear. Now please see B, arbitration as an award. The fact that the arbitration process involves a delegation of the power of the state also must be considered in the evaluation of the process, for the exertion of this power will channel conduct within or between institutions as the case may be, and thus have consequences with which society must be concerned. Now, my lord, please see arbitration as a settlement of a dispute. This is what we primarily focus on, to the exclusion of the other elements. Now, please see D, arbitration as a procedure before a tribunal. This also we focus on. Now, please see E, my lord. This is critical, which is why the court's exercise under 34 and 37 must be cognizant of this complexity. Please see E, my lord. Diverse nature of the arbitration process. It will be evident from the foregoing that one of the fundamental propositions of this article, that it is erroneous to assume that the arbitration process remains the same and is uniform wherever the elements of its structure appear. It is erroneous to assume that arbitration is purely a structural concept definable by the occurrence of the elements noted in the definition at the outset of this article. An individual may be identifiable by the presence of a typical sentient anatomical structure. The personality of an individual, however, emerges when he is viewed in a social context. Similarly, the nature of an arbitration becomes revealed when it is viewed in its social context. For arbitration is a chameleon word, assuming varying significance as the social setting in which it takes place. Now, my lord, after this normative exposition, jurisprudential in nature, please see its application to commercial arbitration. That is what today we mostly engage with. Please have with me page 77. I'll conclude with this. Please bear this in mind, my lords. Please see page 77. Please see Roman 10, nature and role of commercial arbitration. I'll just read this one para and conclude.
Yes.
May I read? The term commercial arbitration implies the arbitration of disputes arising in the life of trade and commerce. A dispute involves a deviational transaction in which an established customary expected course of conduct fails to be carried out as anticipated. The particular parties to the dispute may or may not have been involved before in similar transactions. At least one of the parties, however, will have performed many similar transactions in the past, so that its behavior will have become institutionalized, and there will thus be a pattern of practice or norm against which the deviational transaction can be appraised. The fact that this pattern of practice, which usually involve an external relation of a business institution, is of little social significance. The significant circumstances to be examined and weighed in determining whether a deviational transaction should be approved or condemned are: first, the nature of the established norm of conduct against which transaction to be measured; second, the nature of any general rules of law relevant to such transaction; and third, the nature of any special rules of law established by the party to govern the transaction. Now, my lord, the next two sentences are pregnant with consequence. Thus, no dispute can be said to be isolated or discrete. The parties may be, but not the institutional relationship in the performance of which the dispute eventuates. So we saw a practical example of this, my lords, in IRB Infra, and this is why our courts, particularly our constitutional courts, my lords, must retain that limited scenario 3 power. And I am not, my lords, at all postulating that in 34 or 37 there should be a knight errant, a judge should be a knight errant, or impose subjective conceptions of justice or equity. No. But if the facts are undisputable, if they are clear, then lordships must permit, my lords, modification in scenario 3 also. Because that's my respectful submission. I'm so deeply obliged. Because my notes don't capture this because they were on a wider campus. I'll just, my lords, put in a revised note, just focusing on this.
Yes,
I'm
please.
so deeply.
Next.
I'm only giving a short notes, Your Honor. I'm only on the objective of the Arbitration Act, Your Honor. May kindly have. Some of the objectives of the Act, Your Honor, they are providing speedy disposal of the disputes, providing for amicable, swift and cost-efficient settlement of a dispute. I'm taking just an illustration, Your Honor. In my case, I'm just taking the dates. In 2002, an arbitrator was appointed. 2010, the arbitration award was passed. In a cross appeal, one of the claim was allowed. In 2010, the Section 34 was filed. 2019, Your Honor, the Section 34 was modified by the High Court, Leonard Single Judge. 2024, Your Honor, the division bench set aside on the basis of Mohammed Hakim judgment, Your Honor. 22 years, Your Honor, has taken place. Your Honor, asking us to go back in a case will be against the very objective of the arbitration. Your Honor, let's take an example in a cost efficient, Your Honor. In a civil suit for 10 crores in Delhi, the court fees will be around 10 lakhs rupees. Whereas in arbitration, if there are 3 arbitrators, the cost will be around 37 lakhs 50,000 plus the other expenses, Your Honor. Asking us to go back after 20 years or 10 years, I will say, and give the same court fees again will be the very against the objectives of the Arbitration Act itself, because it has to be cost efficient. The objective is it should be cost efficient also. Now let's take an example again. Let's say in a 10 crore civil suit or 10 crore dispute, Your Honor, the modification is about rupees 50 lakhs rupees only. Arbitrator has passed an award and the dispute is only about difference of 50 lakhs. Now that arbitrator, if we will ask him to set aside that arbitration award, then this amount of 50 lakhs rupees will go only towards the cost of the arbitration itself. So the objective is to see the finality of the judgment should be there, where the arbitrator should feel that, where the court should feel that sending the matter back will itself defeat the very purpose of modification itself. The court should allow in that way, in those matters. Okay, please. That's all.
Was IFPN IF 40905. And a summary of my submission is that the power to modify comes from 34(4). And it should be done only in the manner which is prescribed by the statute. 34(4) does not entail that the court should take cognizance of the matter, because the moment it takes, then doctrine of merger starts applying, which is not anticipated by 34. It's a hands-off approach situation, but the honorable court will always have the power to tell the arbitrator to modify the award. That's my humble submission. Now, because it is also important to note at what stage and why should 34.4 be resorted to in the first instance. Of course, Milos, the learned seniors have already submitted why we should first try to save the award. And that principle actually comes from the pro-enforcement bias that is there in 34 Milos. There's a judgment of Vijay Karya, which is under section 48 of this act, where my lords have held, looking at the language, usage of the word may in section 48. And they say that, look, first endeavor should be to enforce the award, even when we agree that certain grounds for objections are made out. Because the word uses may. The same expression is borrowed in section 34 also. Section 34 also says an arbitral award may be set aside by the court. So therefore, the first endeavor has to be to save the award. The additional reasons why I'm making this submission is also the principle of minimal curial intervention. And second would be doctrine of proportionality means. Now, it may be debatable what is more minimum curial intervention. Is it simpliciter setting aside or keeping the matter with itself under 34.4? My humble submission is that not setting aside the award or not using the draconian provision of setting aside the award actually confers with the minimum curial intervention principle under section 5 of the Arbitration and Conciliation Act. And this is also in conformity with the doctrine of proportionality as well, where for minor errors or small errors or curable defects which can be corrected, resort to 34.4 must be made before 34.2 Milos. Now, Milos, one thing that comes in the way is the sheer language of section 34.4. Now, it has been submitted at the Bar Milos yesterday, and there's a judgment also against me. Kinari Malik Milos, 3 judges. And I just read the provision. On receipt of an application under subsection 1, the court may, where it is appropriate, and it is so requested by a party. So this expression, I think it fell from Justice Kumar also yesterday, that it is so requested by a party, my lords. This has been interpreted by my lords to say there should be a written application. In my humble submission, my lords, that may not be the correct position. Because number one, if they wanted to say application, they would have used the word application because they've used the word application at least 10 places in the statute. So they deliberately avoided the word application. Number two, my lords, in my humble submission, this is not a precondition for using the power. This is more of an ex post facto seeking consent/compliance. Now, the reason for such a submission is that since the court is duty bound to save the award, therefore, party taking that initiative should not be that condition. Number two, the language itself says, first the court will see where it is appropriate and it is so requested by a party. So I'm not saying that this and should be or, but I'm just saying a proper interpretation of it is so requested by a party should mean ex post facto consent. Now, why such a provision is there? Of course, my lords, Learned SG took my lords to the preparatory articles, and those discussions, etc., do not dwell upon why there should be this power of seeking a request or consent of the parties. But my lords, my submission is that it should not be a futile exercise under 34.4 to remand the matter back. For example, there is a situation where mitigation of damages is not considered by the arbitrator. And the award could, of course, go because it will lead to unjust enrichment. So a party would have to consider that is it worthwhile for me to spend money and go back to the tribunal? And at least one party should find sense in that procedure. So only to ensure that it is not an exercise in futility, at least one of the parties must benefit out of that process, and therefore at least one of the parties should give consent to it. If the basis for such was party autonomy, then both parties should have consented, or the provision would have provided for both parties. But it only says only one party needs to benefit out of it. So therefore, only one party needs to request.
But what will be the scope for the 34.4 proceeding?
My
That
lords.
should be formulated in an application. You are saying court will formulate it
My
in an
lords.
order and take the
My lords, I bow down to that, my lords.
Possible in all scenarios.
Correct. So if I were just to go for the literal interpretation on what the tribunal can do once that order, once 34-4 is in cognizance of the court, there's two-level test. One is the means test, other is the ends test. The ends test says that the arbitral tribunal will enumerate the grounds. So the 34 court can lay down the grounds that, look, if you don't change your order, I will set it aside on these grounds. So you are hereby given an opportunity to cure these defects, if at all they are curable. And the means test is, what all can the tribunal do to eliminate these grounds? Take such other action as in the opinion of arbitral tribunal. So tribunal is at liberty. Now, this is not a remand under order 41 rule 23, 23A, 27, where the appellate court itself says that, look, you're supposed to do these things, and the consent of parties is not required. Here, the tribunal is at liberty. Tribunal has the opportunity to eliminate the grounds for setting aside the order. This is the interpretation. However, my lord, there are instances of Singapore judgments, which are also referred to in Learned SG's submissions, where the courts have had put in annexure A to the order, and they have said, look, these are the 4 issues you need to determine now to cure the defects. And the matter has gone back to the tribunal to look into these 4 issues. Of course, there were subsequent disputes of what this order means and what the tribunal can do. But this is one way, my lords, I saw that the courts were exercising this power under 34-4. And contrary to Kinari Malik, my lords, we simply say there should be a written application, because my submission is it can be just a consent of the parties. And there are 2 judgments. One is of Madras High Court, one Calcutta High Court. I have referred to in my submissions. I'll just point out the parameters, I will not read it, which simply says it's a procedural requirement. My lords may have page 5. Page 4 bottom. It's a thin submission.
Have you handed over?
Well, I'll hand it over. I have extra.
Yes,
I'm sorry, because one is not in the form of paper. Fine.
yes, please. No, you are referring to this one.
My name is Pallav Mongia, my lords, should be filed in my name.
Yes, that's there.
That's the one. That's the one. Page 4 bottom is just a 7 8 pages submission. My lords.
Yes,
Page 4 bottom.
yes, where we can refer to MMTC.
MMTC, my lords, absolutely, my lords, and see, I won't read the paras, but my lords, though these judgments say they are procedural in nature, but my submission is it should be mandatory, but in form of a consent, not in form of a pre-application. It's not a trigger point. It's more of a case of ex post facto compliance. Because if the, because my lords, once the court has made up its mind,
You can understand if you say that oral application, written application may not be necessary.
my lords,
When on an oral request it will be made.
my lords,
Then how can it be post facto?
no, ex post facto in the sense ki first the courts made up their mind and then they seek consent, not that after the tribunal exercise. My apologies.
Both.
I'm sorry.
Consent of whom?
Consent of one of the parties. Because it should not be an exercise in futility for the parties.
I think we're going in absolutely. Look, it's for the court to decide. Courts know how to deal with it. When objections are there, normally what happens? The party which is objecting, it can be 2 situations.
My
The party which is objecting to the award may come forward and say, please get it corrected. But the greater possibility is normally the party which is defending the award
Correct.
and
Correct.
gets confronted with a situation where they are not able to defend the award,
Correct.
they may ask them to be sent over there.
So that winning party will make a choice that, for example, mitigation of damages ground is not there.
The party which wants the award to be, defending defending the award. Like in a given case, it can be the other party.
Exactly, Milo. That's my point.
But normally a person which is defending the award, they find it's impossible to defend it. So they say, please send it.
Exactly. So
But
it
then
may say that, look, mitigation of damages considered.
we should not go now going to say how should application should be moved, whether it should be.
No, no, that's exactly my point, my lords. If my lords were to say that this is not a
No, no, the
application
only question
mechanism.
is whether any modification can be done.
Correct.
And
Correct.
if
So
it can be done to what extent?
correct, my lords. Correct. So this is a process which will trigger that
You
power.
know, process is very, the language is very clear, where it is appropriate and it is requested.
It is so requested. It is not an application.
So even if a party makes a request, the court finds that it is not appropriate,
Correct.
court may still reject it.
Correct. Now, I just point out two page numbers. I won't even take my loss to that. There are two Singapore judgments which are referred by the learned solicitor in his written submissions. And in the compilation 4, at page 1772, there are instances where the courts themselves said that you please address me on 34.4. The court invited submissions and it's recorded as part of the transcript, not just a recording in the law reports. my lords.
Yes.
What is the name of the Singapore case?
I'm sorry. my lords, one is Bagadia Brothers.
That's Indian case.
No, my lords, that's Singapore, my lords. Bagadia Brothers versus Ghanshyam at page 1772.
Volume 4. Yes.
In the first para itself, fourth line, my lords, on 12th April 2022. I'm sorry, Justice Vishwanathan.
Right, yes. Yeah, what is the page? 1770. Yes.
My lords, fourth line from the top, para 24. My lords have it, my lords. On 12th April 2022, I further directed the parties to address me on the applicability of 34.4 of the model law to the present application and whether it would be appropriate in the present case to remit the award to the arbitrator. There was no application. In fact, an objection was subsequently
Why are you
taken.
going into all this?
I'm going for all this. my
Courts
lords,
know how to deal with this issue.
No, my lords, because it has been, my lords, in my humble submission, the requirement that it should be a written application, that may not be
Just
required.
read that part.
And if it is so interpreted in such manner, then the power of modification indirectly comes.
We did not go into that question.
I bought the Millers. I just duty bound to share this. Then Millers may have just one more page. On the next page, it's a chart. I'll just show that chart and I'll just end with it. Millers. Page number 8, there's a chart in my written submissions. Millers may have the chart. Just I'm so sorry. I'll trouble you. Just 30 seconds.
So we have understood the chart. It says where there's uncurable defects, it has to be set aside. Where the
First-
curable defects.
Correct, Millers. There must
that's
be
the
a
court will
under
try and
34.
solve it. If the court cannot solve it, then it cannot, can be sent under 34.4.
Correct, Millers. And Millers, Indian Millers, there's just one more.
Done by Mr. Datar.
Almost.
Millers, this aspect was not argued.
Be used, it has to be sent back to the arbitral tribunal
Millers,
Be
in
modified.
priority, it should be used first, try and save.
by the 34 court itself, but it should be sent back to the arbitral tribunal.
No, yes, Millers, it should be sent back to the tribunal. The court itself cannot do it, Millers. That's my humble submission. And if it is got to one question that fell from Justice Vishwanathan yesterday regarding whether quantum can change or not, Millers. There's one judgment of BRS versus BRQ. It's at page 1429, again a Singapore judgment, where the court itself noted that the quantum will change, but since it has to be sent back for the reasons aforesaid, all 34.2 grounds, therefore let that be the consequences. Because in my humble submission, Millers, this is not an opportunity for the parties to improve their case, but for an opportunity to the arbitrator to do a better job and ensure that the grounds are eliminated.
To remove the defects.
To remove the curable defects. Because of course, certain things can't be removed. And conclusion is on page 9. And there's a summary of my submissions also on page 1. I'll end it. I'm obliged. Okay.
Is on this side.
No, you are the other
They
side.
cannot be modified because of the IA was like this. That's why
No.
I can be taken up. Milord.
Any other names?
Our bare bones proposition is that when your lordships are to locate the power to modify or vary, whether it is to be located as part of the power to set aside an award, which is a larger power, my lord, or is it a standalone power which stands in its own right, my lord? My lord, my submission is that as much as the power to set aside is a power, the power to modify is a power in its own right, my lord. But why I would say this is, I've handed over just 5 sentences note, my lord. My lord, although the words used under section 34 is only the power to set aside, my lord. My lord, but there is certainly the power to refuse to set aside the award, my lord, which is to confirm the award. There is also, my lord, the power that if the parties agree, then the court can pass an order in terms of the agreement of parties, my lord. My lord, all these powers are not expressly there, but these powers have not been expressly removed as well, my lord. So, my lord, in my respectful submission, my lord, the appellate court's power is to be traced under CPC, which says that in exercise of appellate jurisdiction, the appellate court can set aside the award, can vary the award, can confirm the award, or with the agreement of parties, my lord, is different kind of order can be passed. Now, my lord, so long as all these powers are subject to the express limitation on the power of setting aside, which is that the court in exercise of section 34 cannot review the merits of the matter, or there shall not be any reappreciation of evidence. Now, that's the test in my respectful submission. That is the test to be applied on all these 4 powers. The power to set aside, the power to refuse to set aside, the power to vary or modify, or the power to pass an order in terms of the agreement between the parties, my lord.
It's an appellate power.
It's an appellate power, my lord, which has not been taken away by this statute, my lord. The Arbitration Conciliation Act does not take any of the powers, my lord. My submission is that the express words relate only to setting aside. Right, my lord? But, my lord, the power to set aside is not to be seen as the power. Power to set aside is a power within the larger ambit of section 34. So 34 is the larger power in which, my lord, there is the power to set aside, there is the power to modify, there is the power to refuse to set aside, and there is also the power that if the parties are in agreement, then a different sort of an order can be passed, my lord. And the limitations only being this, that in exercise of any of these standalone powers, the court does not have to interfere with the merits of the matter or reappreciate the matter. But in that light, my lord, I have, my lord, taken liberty to just request your lordship to view the 3rd referral question. My lord, the 3rd referral question as framed is that whether the larger power to set aside entails the power to modify. My lord, in my respectful submission, my lord, if the words, my lord, if your lordship would have the 2nd page, whether the power, and remove the words to set aside, and it may be read like this, whether the power under section 34 of the act being the larger power. So 34 is a larger ambit, will include the power to set aside and the power to modify. So section 34 in my respectful submission is to be read as a large power. Setting aside is a part of that power as much as the other 3 powers which I mentioned, the power to modify, the power to refuse to set aside, and the power with the agreement of parties. This is my respectful submission. Great.
Lords, I need half an hour for the rejoinder.
Not just now.
Huh?
Not just now. Not at this time.
No, not at this time. No, but I'm saying that if they could never assist your lordships, my lord, my learned friends.
So let them complete and then you can.
That's what I'm saying, my lord, that it would be fair, my lord, that they assist your lordships and give me 20 minutes to half an hour at the end, my lord, when my friends conclude.
Yes, please.
Because I'll take a short while and then Mr. Banerjee will do most of the argument. We've prepared a common compilation between the three of us so that there isn't a repetition. And that's been filed, Millers. There's one note that we prepared. What he says. They're just coming shortly at the note is coming.
Ancestral compilation, the common compilation.
Yes, Millers.
Now there are
There
three
are
views.
six volumes.
There are three.
There's six volumes.
There are three views which are coming. Or we can divide broadly into three views. One is that the power to set aside subsumes in it power to modify, in which cases will you modify? When will the court exercise the power of modification? Will be relatable to curable defects, not something which are uncurable by the court. But this has to be done. One aspect, one side says this should be done without going into the merit or reappreciation of evidence. There may be some difficulty in that, because whenever we are going to the patent illegality public policy clause, there is element of reappreciation. But not as an appellate court, but as a court within the confines of that power. See that. The second issue which has been argued sometimes is that the court may not do it. It can always then exercise the power in appropriate cases under law section 4 to section 34. The third view is where the court can do it, it should do it. But where the court finds it, it cannot do it. And there is some way then you leave it to the arbitrator to carry out that exercise. That's a argument.
I think one thing we must remember, and the other side certainly must remember, is that we are not indulging in some kind of a legislative exercise. This cannot be a de novo.
No, they have not argued. None of them have said it's a legislative exercise. They have gone on jurisprudence to say set aside is a wider term, so it will subsume a lesser power.
Unfortunately, Mr. Datar has specifically handed over a page where he has said that these words have to be added, these words have to be removed. A legislative exercise can either be on the face of it or by a sleight of hand. You can say, please add word to the statute and be honest about it, as Mr. Datar rightly was, by saying, please add these words. And hence, that is how the statute should read. The other way is through some process of extremely creative interpretation to such violence to the language of the statute as to amount to a legislative exercise. Well, that will also amount to a legislative exercise, and that is going to be our endeavor. That in the process of trying to remedy a perceived fault or a lacuna, we cannot do violence to settle principles of law, both of interpretation and separation of powers. It may be a crying need and a crying necessity. And I think parties probably will agree that there is a need. The worry is that if there is through a judicial interpretation.
The moment you say there is a need, you get into a.
No, I will say something different. What I'm saying is, you may have a need. Some people may feel there is a need to intervene. In fact, my note says that there is no need. We've had 30 years from 1996 without this power of a modification. The systems have not broken down. There may be individual odd instances of injustice. That happens with us even in the regular courts. That doesn't mean we do away with the justice system because there are some wrong decisions. Just because in certain instances, some people will have to spend money because of remand, doesn't mean we take this entire system which has existed of setting aside alone as being the power and replacing it with something which may be far worse. Modification will become a hydra. There will be litigations upon litigations as to whether this amounts to a modification or setting aside. Is this curable? Is this non-curable? As of now, we have 1 round. We will have 5, 6, 7 rounds. Well, the remedy will be much worse than the disease which is perceived to exist. And I say that disease does not even exist. Who has come on a regular basis and said there is a massive problem with modification? Yes, there are problems on odd occasions. But does that mean that we do such violence to the act and the language of the act to rescue millets from this monsters hiding in the shadow? That is going to be the argument. How many cases will every person who loses will say, don't set it aside, modify it? In every case, this is going to happen. When the matter goes to a section 34 court, one side will say uphold it, the other side say no, modify it. There will be a refusal to modify or a modification. 1 round of litigation with that will happen. Rather than being an expeditious process of arbitration, being a fast resolution process, it will be exactly the reverse. The consequence will be worse. Therefore, millets, and that is why I'm saying it may not be desirable. And if it is desirable to a limited extent, it is for the legislature to hem in very restricted terms as to when or what circumstances can be modified. Those millets.
For the legislature, that can we say that the legislature has to do it for narrow purposes?
That is for the legislature to do. We may not like it. We may want to have the power, but that just because we want to have the power doesn't mean you have the power. And the legislature may find creative ways as to how to rein in the power of modification when a judicial test is laid down by court. Inevitably, the interpretation of that will become wider and wider and wider as we go through time, with courts all across the country interpreting the judgment of my lords. We saw that with ONGC saw pipes.
You are proceeding on the assumption
Yes,
that the statute as it now stands doesn't permit.
Doesn't. So that's what
You have to first deal with the point
we will, Millet.
that the statute as it now stands forecloses
Correct, Millet.
even the nature of the modification as suggested.
Absolutely. Well, what I'm dealing with the other side is we must keep this in mind.
Basic submission is that if there is a power to set aside, it's a wider power. And therefore, if there is a wider power, then a smaller power can be exercised.
It's dealt with my note, and I will.
And like Mr. Datar argued, if the legislature wanted a prohibition, then it could have provided a prohibition as has been provided in the Singapore Act.
Yes, sir. On that Section 5 and Singapore Act, which Mr. Banerjee will address, saying that it is identical. The Section 5 of our Act is identical to the Singapore Act. And Millers, I will just
5 of the UNSIT Act.
And I'll show one judgment, Millers, of in the Stamp Act case, where this is discussed as to what is the scope of the courts. And Millers, a lot of discussion has happened about the policy of the Act itself. I'll come to all of those, but just quickly address Justice Gavai's point on the lesser includes the smaller. There's a very important question is what is the greater and what is the smaller? Is setting aside the greater power, is modification the greater power? It could well be argued, Millers, and I intend to argue that modification is in fact the greater power, which will include within it setting aside. The correct way to see it is both setting aside and modification are 2 separate streams, 2 separate powers. One doesn't flow from the other, one is not greater than the other. The 2 are simply different things. And that is why, Millers, our jurisprudence in the 1940 Act, as well as in the CPC, has recognized these powers as distinct and separate. When we start saying, Millers, that setting aside will include the power to vary, some will also argue and can be argued that since the greater power has a lesser power, and you have the power of setting aside, then that setting aside power will also, in a case of a regular appeal, Millers, as a matter of law, because my laws will be deciding as a matter of law, does greater include the smaller, applying not just to arbitration, the implication would be in a regular appeal. The greater power includes a smaller power. That would also imply maybe the power of review, because review is less of a power. This court has always said review is a substantive power. But if this theory of lesser including this is included in the greater, then Millers, why would review not be included in the greater? On what basis can we then say the courts don't have a power of substantive review? Because that will be the inevitable effect. Because when my lords decide, it is not just an attempt to cure a problem in a particular statute for a particular problem.
No, review. Merit review is on the scope of the power. This is on the power as
yes, Millers, what I'm saying
contemplated within that contemplation.
Correct. If the argument is going to be that the power to modify is a subset of the power of setting aside, and setting aside is such an extreme power, every appellate court has a power to set aside an order.
See, the argument is very simple. If you can set aside, that means you can destroy the award. Why should it have a subset that the court can exercise the power to modify the award and ensure that the litigation comes to an end. After all, practical reality is that litigation should come to an end. And
Unfortunately,
rather than having so therefore the argument is not based upon that a new power be conferred on the court. They say power to set aside includes in it the power to modify. Yes, the power to modify will have to be exercised within the four corners of law.
Yeah.
That is, that without going into, it should be curable defect. It should not be non-curable defect.
well, I'll come to that. The point is, just as a preface, is when you start reading a different kind of power into another power. What my lords are being asked to do is, by saying that the power to set aside includes a lesser, so to say, lesser power of modification, by implication, therefore, setting aside includes modification, is erroneous for the simple reason that it is not as though it is a lesser, greater, sideways power. It is a different power altogether. One that has been recognized in our jurisprudence in the 1940 Act. Because if the power of setting aside included modification, there was no need for the Arbitration Act of 1940 to use the word modification separately. There was no need in our Code of Civil Procedure, in order 41, I'll take my lords to it, 41 rules 24 to 32 to say pass an order, vary, etc. Then the appellate court would only have the power to set aside a judgment or uphold a judgment. It has always been the view of the courts and the jurisprudence in our country that the power of modification, which is actually the language used is variation, is different from the power of setting aside or upholding. These are different and distinct concepts because, and that's why I mentioned review. Review is also a distinct concept. But if one power is supposed to be read into another, then why in the power of setting aside would you not also read in the power of review in a case of an appeal, which has never been the case? There are judgments which are clear that power of substantive review is a distinct power. Nevertheless, review the same species as modification when it comes to the alleged greater power of setting aside. This is Kumar's question.
The substance of section 15 of the 1940 Act,
Yes, it is.
it has been smuggled in.
Correct.
In the 1996 Act, partially setting aside in 34
Yes,
to be proviso.
correct.
And what is that, 34 to
33.
to be proviso, and 33,
Yes.
is it not?
Yes, well, but one portion is not.
Is the absence of the word modify in the 1996 Act to be given so much significance in the light of this?
That is not at all my case. My point is, as a concept, modification is always seen as a distinct concept from setting aside. So even that power in the 1940 Act, while it has been smuggled in, to use my lord's words, into the 1996 Act, it has been smuggled in legislatively as a different concept. Because if it is not a part of the setting aside, there is no need to smuggle it in. Because the power of setting aside will include all powers. Then why have section 33? Why have section 34(4)?
Accepting your argument, the wider power of setting aside may subsume within it the power to partially set aside.
Yes, power to set aside is the same as power to partially set aside. That is a subset. That would be the subset. Mr. Datar had cited a case of Atmaram. Atmaram was a case, the question was whether under the constitution, I'll take my lords to it, whether you have the power to regulate an estate, whether certain rights under the estates or holdings would also be regulated. That is clearly a subset. When you have, we all know property is a bundle of rights. When you give authority to deal with entire property and you deal with some of those rights which constitute that bundle, it's a lesser subsumed within the larger. Is conceptually, however, modification and setting aside fall within that frame of reference? Not at all. It is entirely different. Well, it's just because we're looking for a mechanism to find that power doesn't mean we can start doing violence to these concepts, which have been known to our courts for a century. As I said, we'll see.
We are not looking for a mechanism because Hakim says
yes,
you can't do it.
Yes.
We are considering whether it is correct.
Correct. I'll take my last
process. We are faced with all these submissions.
Yes, but I'm not saying when I say my laws are being asked to do it. My laws are being asked to read into the power of setting aside a power of modification or variation. As I said, please look at the CPC, Code of Civil Procedure.
1940 Act.
Order 41. My lord knows it. We've seen it several times. My lord, they've also seen section 5 and 34 several times. Sometimes, well, it's... Please see order 41, rule 32. And this is 1908. So this is something over 100 years ago that the legislature knew. 4132.
Yes.
The judgment may be for confirming, varying or reversing the decree from which the appeal is preferred. There are three propositions, there are three separate things that have been given. You can confirm, you can reverse, or you can vary. These are all distinct powers which have specifically been given by statute. This has always been the understanding. The problem is if the power of modification is to be read into the power of setting aside, then my lord will see all the other rules that are required to effectuate that also. See, for instance, order 24, order 41, rule 24. When the evidence on record is sufficient, appellate court may determine the case finally. Because appellate court is given all the powers to vary, modify, and decide. That is, none of that is given, Millets, in under section 34. Where are we reading all this into? Entire elaborate scheme which is given in the CPC of order 41, rule 22 onwards to 32. None of this is present. How will the procedure work? And why should such a procedure work? Well, that is my point on the larger, but I'll come to my note. The note has been handed over. This is roughly sum and substance of it. So we have to look for the conceptual basis through which any power of modification is to be found. It has to have a basis in law. Its first can be done through the process of adding words to a statute, which was the argument of Mr. Datar. He had specifically given a sheet saying, please add the words or partially set aside, comma, modify. That was given to my lords. That has been a specific argument of the other side, not Millets, something that is, the problem is this, sometimes this is lost in the flourish of argument. My lords will read this. The petitioners have argued that the power to modify an award. However, there is an absence of conceptual clarity as to where this power is located. Some of the petitioners argue that the statute be amended and certain words added allegedly to make the statute workable. And Millets, we say that this argument of Mr. Datar to add words to a statute cannot be made to make it workable is wrong for several reasons. First, Millets, the general law of the land is my lords will not add words to a statute. That's the general principle. First principle, because I thought that is rather obvious, but it is important still, Millets, to put it out to my lords that my lords do not add words to a statute. But some months ago, Millets, we were arguing on the other side saying you add words to certain other statute. Millets, was not added by this court, saying that we don't have the power, only Parliament can do it. Well, it's the same thing here, that there is no power in Millets, an arbitration act also, and it will be done by the legislature. Source of the goose, source of the gander. So Millets, there is no general power to add words to a statute. Second, Millets, they say there is power to add words to a statute in certain cases when the statute is unworkable. Millets, it is not as though the Arbitration Act of 1996
Or to save it from absurdity.
Yes, but how is this absurd or unworkable? It may not be a desirable effect to some people. But for the last 1996 till 2024 or 25, this system has worked fairly well. It is not as though arbitration in India has collapsed and no one is going to arbitration and people are rushing to court for justice, saying that because there is no power to modify, look, there is an absurdity.
But let's be very frank, I think it's almost 10 to 20% matters this issue is arising.
Yes,
At least before this court.
Matters.
But number two, when you say partially set aside an award, that's also modification of the award itself.
No, that is.
It is, because you are saying that this part of the award is to be segregated. And that power exists regardless of the power given in the proviso. We have not restrained it only to the proviso to 34 2B. We have given it a much wider meaning.
Millets, I'll explain as to why a power to partially set aside can very well be implied without doing any violence to the language. For
And
two
it's
reasons.
very, it's normally, as a principle of interpretation,
Yes,
you don't interpret a section by reference to another section in another, another enactment.
certainly.
That's normally not done.
Absolutely not. Well, what I'm saying is sometimes it becomes a bit of a khichdi argument. We take some concepts from different ideas and put in a cocktail shaker and there out it comes. However, we have to have a conceptual clarity as to what the court can do, what the court cannot do, in which instance can the court do what it can do.
It can be argued, if you look at 33, every attempt is made by the legislature to ensure that the award should, because it's one-step adjudication.
Yes,
Yeah, arbitration is one step until unless they're two-tier arbitration. It's one-step adjudication, which has its drawbacks.
Correct.
One-step adjudication always has its drawbacks, and sometimes people don't like being put into one-step adjudication. But the legislature attempt is to ensure, even if it's a one-step adjudication, there should be corrective measures available to the parties, whether in form of 33, whether in form of 34(4), or in form of proviso to
Well, I would submit that it is no part of the policy of the Act to uphold an award come what may. Or this is not the IBC, and I've made that my note, where the policy of the Act is always save the company, no matter what. The policy of the Arbitration Act is very clear, Millets, and that has been discussed. We can't start importing that just this is the policy or that is the policy. It has been judicially determined. Arbitration is an alternative to a very slow process of litigation that commercial parties often do not wish to have. Because there is an economic cost involved even in delay. An expeditious decision, even if sometimes unfair, is possibly more acceptable to business than a correct decision, which will eventually take 50 years. Because parties cater their economic planning in a particular way. They have to plan also. If there is always a constant doubt as to whether an award will be upheld or set aside or modified, or this will happen, well, this will create economic chaos.
That is their argument that suppose if the award is set aside.
Yes, Millets.
And it is set back entirely.
Yes.
It will add to further delay because the process will start from zero.
Millets.
If the power is exercised to vary it will curtail the further litigation.
That is the whole point. My lord assumes that it is in the rare occasion that a court will modify the award, and rather than setting aside and sending people back to the arbitration, rather than doing that, we'll just tinker it here. That tinker it here will no longer ever remain. Just tinker it.
Irony is even where it was held that you don't have the power to modify, court is declared.
But that's under 142. And the wisdom of this court, Millets, is given constitutionally by the framers of the Constitution under 142. That wisdom that my lords have has not been.
If we go strictly by the principle of 142.
Yes, it is.
If it's contrary to the fundamental principles of law,
yes,
you can't excise 142 to.
Well, it's the idea of. That is subject matter for another decision.
No, that's settled now.
The SCBA's judgment, my lord knows. We all know the Supreme Court Bar Association, Justice Anand's judgment. That's true. But if at all a power is to be exercised, it can be exercised maybe by this court, partly because it will not be further challenged. That's on a lighter note. But the fact of the matter is, if this power of modification is given, rather than settling the matter once and for all by some court saying, all right, rather than referring you back, we will do it. That modification will happen in every instance. It will be a boon for the lawyers. That without doubt is the case. Whether it's so good for the clients, Millets, we are not so sure. So the remedy will be.
All that will happen is both parties will appeal under 37.
Yes, Millets. So rather than one party
setting aside.
There will be another round. First, there will be a round, Millets, on.
Anyway, there is going to be an appeal. So
there will be first appeal First, on the question of as to whether it is, you can modify or not. Secondly, there'll be an appeal on whether it is curable or not. Third, once it is held to be curable or not curable, to the extent of being cured. Well, this will blow a hole through the entire arbitration process, which has worked reasonably well for 30 years. Again, coming back to this, there have been instances of problems, I'm sure. But Miller, there have been instances of problems, as I said, with the justice delivery mechanism as exists currently with the law courts. It's not as though every judgment is correct by every court. You have appeals. Sometimes, Miller, and even a final decision is ultimately reviewed over the years later by the court. But that doesn't mean that just because there is a possibility of an error once in a while, we do greater damage without considering the consequences. Because this court does not have the expertise, with the greatest respect, to examine as to what will be the effect or the consequence of allowing modification power to be read in as a policy. Well, the reason I'm making this argument in law is that the argument was made. If I just now go to my note, otherwise I'll be as guilty of having vague arguments rather than specific on. So the first was on adding words to the statute. Can't happen because the general law does not permit. Second, that it is not as though the statute is unworkable or unfair or unjust. It may result in certain injustices, but the statute works. And third, Millets, the general principle of adding words to a statute is well referred, Millets, to a violation of fundamental rights, where a statute is vulnerable by being contrary to some fundamental right. Article 13 says you will strike down that law. So the courts have devised a principle, Millets, ut res magis valeat comperiat. Rather than striking down the statute, we will read it down or we will insert words so as to save it from the vice of unconstitutionality. There is no such thing in a commercial statute like the Arbitration Act. No one has argued that because this is violative of a particular article of the Constitution and therefore is bad, therefore to save it from the vice of unconstitutionality, please read the words in. Well, if this principle is to be adopted, that you can start reading words in even without a threat of unconstitutionality, that will be a remarkable advancement or change, at least, in the law. That is not the law. For fundamental rights, you can do it.
What should interpret the provisions in a practical and pragmatic way to curtail further litigation?
Yes, Milind. That will come to the next point. I'm saying that Mr. Dattar's argument that please add such and such words explicitly made is explicitly incorrect for the following three reasons are given. So when the words cannot be added to the statute, then how does the power to come to modify? There are two principles that have been given, Milind. First principle that has been given is that the word setting aside itself means somehow modify. And the second is a theory of implied powers, that the greater power includes the lesser power. That's the two fundamental logical bases. So as regards the first point, as to the setting aside somehow includes the power to modify, there I only have to refer to the learned solicitors Black's Law Dictionary and Oxford English Dictionary. Setting aside means annulment. If there's any doubt in that, my lord will come to Hakim. Hakim has not been cited to some length, even though this is being reviewed. I just ask my lords to turn to Hakim and see how the learned division bench of this court examine this. That would be in volume 1 of our compilation. Page 1. So Mr. Dave will of course be aware of it because my lord was part of this bench.
Solicitor's compilation also.
It's also in the solicitor's compilation. But
7 volume for all the
we made our compilation with all our side so that there is no repetition duplication. My lord wishes, we can refer to the
Give me the original one. Don't give me this one.
My lord can take the solicitor's volume. I'll give the paragraph numbers. Yes, please. My lord will take the solicitor's and I'll use that. My lord will take the solicitor's compilation, which is, where is this? For the page number in the solicitor's compilation. Does my lord have it?
Solicitor's compilation page 11. SEC.
Yes, please. It's a new computation. May I give paragraph numbers so that my lord can then follow it? Lord, let's see, read paragraph 2 as to how the matter came to court. To the matter under the arbitration under the NHAI, the appeals in the present case raise an interesting question of law as to whether the power of a court under Section 34 of the Act to set aside an award of an arbitrator would include the power to modify such an award. A division bench in the Madras High Court has disposed of a large number of appeals filed under Section 37 of the Act, laying down to the matter of law, at least insofar as awards under NHAI, that 34 must be read as to permit modification of an arbitral award made under the National Highways Act. My lord will then come to, my lord will leave the submissions. Mr. Mehta Milad was saying, had made the same submissions as he has before my lords in paragraph 5. But Milad will come to the findings of the case in paragraph 16. Because the court examined the policy of the Act as well. Because much has been said about what the policy of the Act is. But it's all discussed in this. Paragraph 16. What is important to note is that far from Section 34 being in the nature of an appellate provision, it provides only for setting aside on very limited grounds.
You can go ahead.
Yes. Grounds.
Yes, please.
Provides on very limited grounds, such grounds being contained in subsections 2 and 3 of the Section 34. Secondly, as a marginal note of Section 34 indicates, recourse to a court against an arbitral award may be made only by an application for, and highlighted, setting aside such award in accordance with Sections 2 and 3. Recourse is defined by P. Ramanatha Iyer's Advanced Law Lexicon as the enforcement or method of enforcing a right. Where the right itself is truncated, enforcement of such truncated right can also be only limited in nature. What is clear from a reading of the said provisions is that, given the limited grounds of challenge under subsection 2 and 3, an application can only be made to set aside an award. This becomes even clearer when we see subsection 4, under which, on receipt of an application under subsection 1 of Section 34, the court may adjourn Section 34 proceedings and give the arbitral tribunal an opportunity to resume arbitral proceedings or take such action as will eliminate grounds for setting aside the arbitral award. Here again, it is important to note that it is the opinion of the arbitral tribunal which counts in order to eliminate the grounds for setting aside the award, which may be indicated by the court in hearing its Section 34 application. So even 34 formulas first starts from the arbitral tribunal. Then para 18 is important as to what setting aside normally means in international law. Redfern and Hunter in international arbitration states that the model law does not permit modification of an award by the reviewing court as follows. The purpose of challenging an award before a national court at the seat of arbitration is to have that court declare all or part of the award null and void. There is no question of modification, Millard. It's null and void, internationally accepted, internationally recognized. If an award is set aside or annulled by the relevant court, it will usually be treated as invalid and accordingly unenforceable, not only by the courts of the seat of arbitration, but also by national courts elsewhere. This is because under both the New York Convention and the model law, a competent court may refuse to grant recognition and enforcement of an award that has been set aside by a court of the seat of arbitration. It is important to note that following complete annulment, the claimant can recommence proceedings because the award simply does not exist.
1 minute, please. This was highlighted by the solicitor also.
Yes.
What has happened is, what was pointed out by Mr. Datar was, jurisdictional model was really relating to international commercial transport disputes. So when you are interpreting it, where the Indian domestic awards or the Indian domestic arbitration, do not keep those in mind, because we are then going back at point of time. We are then going back in point of time. Yes, we often use the word that the court power of interpretation is reflective of the legislative intent. But that's all. Legislative intent is then gathered by us and not by the legislature. So while doing it, we if we apply this principle, we are applying this principle which relates to international. There's a difference between international arbitration because then the concept of the law applicable to that arbitration proceedings, the substantive law, the law applicable to the arbitration procedure of that country, all these issues come in.
Actually, they've already come in and said another side as to whether the seat and venue of arbitration and domestic arbitration.
No, seat and venue does come in, but only with respect to the court.
Yes, Milad.
But not with respect to the law which is applicable.
Milad, I'll make a simple answer to that. My lords are saying to me, as Mr. Datar has argued, is that the UNCITRAL model law and this discussion of international law will have no relevance because that is in the context of an international arbitration. Unfortunately or fortunately, Milad, that is not the case because my lords will read the preamble to our very act. Yes,
It does say that it relies upon the.
Have at some point not to forget what the legislature has done. No matter how much we may wish otherwise, if the legislature has not only consciously adopted the words of a statute of the UNCITRAL model law, we have been take the preamble with me just for a moment. Please read the act. Whereas the United Nations International Trade Law has give due consideration to the said model law, not something else. That said model law in view of the desirability of uniformity of the law of arbitral procedures and the specific needs of international commercial arbitration practice, and whereas UNCITRAL has adopted the UNCITRAL conciliation rules, and whereas General Assembly of the United Nations has recommended the use of the said rules in cases where a dispute arises in the context of international commercial relations and parties seek an amicable settlement of that dispute by recourse to conciliation, my lord will see then. And whereas the said model law may be the 85 model law, makes significant contribution to the establishment of a unified legal framework for the fair and efficient settlement of disputes arising in international commercial relations, whereas it is expedient to make law respecting arbitration and conciliation by taking into account the aforesaid model law and rules. This last paragraph is as clear as can be. It has been made. Yes.
You read para 3 of the SOR also. Para 3 of the statements and objects.
Yes, please, I'll come to statement. I'll start with paragraph 1 because even that is relevant. The law on arbitration, because all of it has to be read. Of course, judgment. I'm trying to show that this was not some willy-nilly endeavor done in the blind, unaware of what UNCITRAL decided, and we had a different thing in our mind as to what setting aside means. Everyone in 1985 and 1996 was very clear, and Parliament was certainly very clear as to what setting aside means. It has a specific context and a meaning in international law, Millets. It is not just the 1996 Act. Even prior to that, the Foreign Awards Enforcement Act, Millets, the 63, Millets, the 40 Act, all of these had the concept of setting aside. Parliament was aware. It's not a new concept suddenly accidentally filtering in to domestic arbitration to the root of international law. No, that is not the case. Parliament was aware, and therefore, my lord will see the statement of objects and reasons. The law on arbitration in India is at present substantially contained in 3 enactments, namely the Arbitration Act 1940, the Arbitration Protocol and Convention Act of 37, this is the Geneva Convention, and the Foreign Awards Recognition Enforcement Act 61, this is the New York Convention. It is widely felt that the 1940 Act, which contains the General Act of Arbitration, has become outdated. So an attempt to move away from the 40 Act, and instead the power modification is now read in, it will become like the 1940 Act again. So the attempt of the legislature to move away from the 1940 Act is effectively being argued against, which contains the general law of arbitration become outdated. The Law Commission of India, several representative bodies of the trade and industry and experts in the field of arbitration have proposed amendments to this Act to make it more responsive to contemporary requirements. It is also recognized that our economic reforms may not be fully effective if the law dealing with settlement of both domestic and international commercial disputes, but both, remains out of tune with such reforms. The intention is very clear. Like arbitration, conciliation is also getting increasing worldwide recognition as an instrument for settlement dispute. Therefore, there is however no general law. I'll read the whole thing. I'll read 3 as well. The UNCITRAL adopted in 1985 the Model Law on International Commercial Arbitration. The General Assembly of the United Nations has recommended that all countries give due consideration to the model law in view of the desirability of the uniformity of the law. Again, they want every domestic municipal jurisdiction to have the same law. Which law? Which is the 1985 model law of the law of arbitral procedures and the specific needs of international commercial practice. The split millers is you generally adopt this where there is some variation. Therefore, we have part 2 of our act. The UNCITRAL also adopted in 1980 set of conciliation rules. The General Assembly of the United Nations has recommended the use of these rules in case where parties arise in context of international commercial relations, parties seek amicable settlement by recourse to conciliation. And important of the UNCITRAL model law is they have harmonized concepts of arbitration and conciliation of different legal systems of the world and thus contain provisions which are designed for universal application. All across the world, setting aside means setting aside. When it doesn't mean, provide for a difference. If we want harmonization, we can't in India say
that harmonization is something different. What they're saying is by the same law, but the fact of the matter is several countries, including the Western world, where arbitration is perhaps the default mode in commercial arbitration, commercial matters, they have power of modification.
no, that's statute.
You can't argue that if you bring in modification, you'll be violating the international.
No, that's not what I'm saying. What I'm saying is a particular understanding. I'll read this line again as to what I'm trying to say. What I'm trying to say is that the UNCITRAL Act and our Act was.
You may be right to that extent. You may be right to that extent. But during the course when the discussions was going on, whether model international law of international. At that time, they said modification should not be, there was debate whether modification should be included or not, and they left it. They left it at that.
Yes. Look, what I'm trying to say is, what is the word setting?
It is clear that
yes,
they did not want to lift it as it is for the domestic arbitration.
I'll read paragraph 3. Let's read this. But while reading paragraph 3, we can't forget the last line of paragraph 2, that the intention is to actually adopt that 85 model law
as a model law.
As a model law.
With certain modifications necessary to.
Certainly. But unfortunately or fortunately, none of those modifications happened. It was open to the legislature of India when adopting that 1985 model law to make suitable amendments. Where they made suitable amendments, we know. Where they've not made, they've not made. And where they've not made those amendments, we can't then say that even though you chose not to make those amendments, we will somehow read a power that there was an intent to depart from what was commonly understood. What was commonly understood in 85 and 96, setting aside means only setting aside. The legislature chooses not to depart from that. It was open to it. They chose not to depart from it. Having chosen not to depart from it, we can't say that even though they chose not to depart from it, merely because they could have means that they have. That does not follow, Millers. It was open to them to do that. And in fact, I would argue the reverse. Even though they could have, but they didn't, means that setting aside means only setting aside. Because we are sitting here in an interpretive exercise. We are not sitting here as legislators or in some kind of constituent power. If the intention is to be determined of Parliament, the intention of Parliament is very clear, whether we like it or not. The intention of Parliament is clear that what does the word setting aside mean? Setting aside, Millers, it's Lord Atkins, famous Liversidge and Anderson. Words mean what they mean. Setting aside, we all means annulment, which is why we are now struggling to find modification, variation elsewhere, which is why CPC always says modification is different from variation. The Arbitration Act says modification is different from setting aside. This concept of setting aside is conceptually different. There is no way of reading into the idea of setting aside and a concept of modification. I'll come to the second argument, which is that it is a lesser or a greater power. But I'm on a point A here, which says that you cannot interpret the word setting aside in any manner other than its natural meaning and the meaning as described in Redfern and Hunter. And as understood by every country across the world, as understood by India in 1985 and in 1996, suddenly, Millers, in 2025, they can't suddenly be waking up and saying, no, actually, that's not what they meant. What setting aside meant was modification. Well, this stroke of genius that we lawyers sometimes get to read words interestingly and differently, cannot work when the words of the statute are clear. They're as clear as daylight. We may not want it, I repeat, we may not want it, you may not like it. But there has to be some judicial discipline, Millets, also, with the greatest respect. Because, Millets, I repeat, nothing is a greater anathema to the world of commerce as unpredictability. This constant flip-flop, change, etc., Millets, is actually a greater danger. Two parties have decided that we can go to court.
I don't think that argument, the last argument will work, because the commercial world also wants certainty in litigation.
Yes, Millets.
And not continuity of litigation.
Millets,
That's the argument of the other side is, why do you expect courts will not be able to be appropriately apply the law, even if it is modification, in cases where there is need and strictly within the four corners of law, without going into the merits of the matter, without going into the examining the rewriting the award. In those limited set of, they are not asking that it can be court can sit in a judgment in an appeal. And as was suggested in some of the cases, in one or two cases that is suggested, but most of the advocates on the other side have never said that we should become the appellate body. Nobody said that, except probably in public policy matters relating to NHAI.
Well, the question is not as to what is desirable.
Nobody's argued.
It is a question, Millets, of what is the law. That's what I am on.
Let me put it very clearly. As far as commerce is concerned, that may not be. The first argument of yours,
No, Millets.
that if we have adopted the unilateral model
Yes.
and the intent of the legislature was to exactly take up the unilateral model, then setting aside doesn't include modification. To some extent, maybe right.
Well, look, again, just as a legal framework, is just put it back, skeleton of legal framework. You can't add words to a statute. You can give. Well, I'm just finishing my point. Second is you can read modification into setting aside if the words itself have some ambiguity and permit for that. I'm argued that is not the case. That is not possible. There is no ambiguity in the meaning of the word setting aside. Through no process of interpretation can we read variation into the setting aside. That's the second point. Third point, Millets, is whether the greater includes a lesser. Millets? In another way, Millets, I suppose, of saying that the word setting aside may include variation or modification, even if the golden rule of interpretation, which is read the words as they are, is not to be taken, and that was also argued by the other side, is through some form of purposive interpretation, that you interpret the words of a statute so as to effectuate the policy behind it. That has been a substratum of a large part of the argument of the other side. But I'll say some things to that. One, that principle can only be adopted when there is an ambiguity in the words of a statute. It cannot be adopted generally. Where is the ambiguity in the word setting aside? It's as clear as daylight. It's clear, Millets, to us in 85, in 96, to this court, Millets, in Hakeem, to Redfern and Hunter, to every country across the world, which was given a separate power for modification. So they know what setting aside means. It is clear to our legislature in 1908 in the CPC when they say there's a different power. To all authorities so far, these two powers have been seen as distinct, and setting aside means setting aside. Well, it's English language. So therefore, there is no scope of a purposive interpretation. Then if my note is to be seen, then assuming a purposive interpretation is to be adopted, then two things need to happen. First, you determine what is the policy of the act. And second is to ask yourself as to whether the interpretation being sought to be offered will further that policy of the act. Both things, Millets, in purpose of interpretation, my laws will do these two tests. What is the policy of the act? Very often it has been said that, look, it becomes very expensive, very expensive. No part of the arbitration exercise is to make it cheaper for parties. It is well known that arbitration is more expensive. What is important and has always been stated in every judgment of this court, including the Stamp Act judgment, if need be, I'll refer to it, is the policy of the Arbitration Act is twofold. One is minimum judicial interference, embodied in Section 5. And the second is expedition. Expedition and non-interference. And Millets, I would dare say that non-interference is a concept which is in furtherance of expedition. But if non-interference is the purpose of the act and expedition is the purpose of the act, one, I would say, leave the expense of the parties away. Parties know when they choose that they're going to arbitration that they may come with a situation where the award is set aside and they'll have to restart it. They do that in commerce. It is not a problem. It is parties well know that. Yet they choose to opt out of a general judicial system and go to arbitration. So let expense, please leave out of it. The consideration of expense, parties are presumably factored into their own mind when signing that contract, because it is party autonomy. Parties know what they're doing. So the question is, Millets, of expedition. Millets, if legislature says section 5 in furtherance of expedition, I dare say the question will then come to the second part of the purpose of interpretation test is whether modification and the power of modification will expedite the process or further retard it. By reference to 3 examples coming from other side, think, look in my case, modification would have quelled the litigation there and then, forgets the fact that it would, I repeat, in this court it may quell it because there is no further ground of appeal. If that power is to be exercised by every single trial court, even the high courts will exercise a trial jurisdiction when they have original side. But it is also exercised by district courts in every country. In every court in this country, there will be an application of a modification, no matter what guardrails my lord gives of curable, incurable, this, that. Every party will say, well, look, this is a curable defect, cure it. You can do it. The other party will say either you should not have cured it, it is inappropriate, or it is not a curable defect. There will be one round of litigation which will go on that alone. Because I give again the salutary example of ONGC.
That may not be correct for a simple reason. The power to modify will only arise in case the court forms a conclusion that the award is patently wrong or contrary to public policy, and therefore it's liable to be set aside. First, you have to form that conclusion. You cannot, without forming that conclusion, modify the award.
Yes, but then my laws will then, if they give my lord gives a restriction saying having come to this conclusion of patent and legality.
Therefore, the expedition part is therefore built into their argument that first we have to form that. Therefore, they argued that way. They said, please do not read the award that we are asking to take the power of the appellate court. Don't read it like that. Except some of the counsels did argue in public policy matter, the approach of the court in 34 should be much broader and wider.
Because I ask myself,
And to be fair to them, they also argued about 300A. So that was also.
I'm not such a jurisprudent as to.
They argued about 300A, saying that a property is being taken away. What is being given, what is the adjudication, the arbitration is by a government officer. And therefore, if you're not going to read 34 broadly, to include the power of modification, it may lead to difficulty. So Arbitration Act, as enacted by the Parliament, is not only being applied to pure commercial matters, it's a list of 9 acts where Arbitration Act or the provisions of Section 34 have been made applicable in statutory arbitrations also.
There's one very simple answer to that. You are now using a different problem to solve a different remedy to solve a different problem. If the argument of 300A is that you need recourse to a wider power of re-examination, then Miller's this restriction of 34 of patent illegality and public policy is wrong. It's not modification. It's not what court can do with it. You would then need to challenge the substantive act and say that my recourse to court is limited by these principles of public policy and patent illegality, these narrow forms. That is under challenge, Millard, not what the court can do having found so this argument has really no merit. Then you please challenge those individual acts and say that why are you following arbitration with its restricted appeals? Please follow a regular procedure. You file a writ petition if need be, you go to court, you challenge that act, whatever. This will not solve anything. Reading the power of modification will not solve the problem of 300A as long as the rest of Section 34 stays. Because then that is the ground, because if that argument is to be adopted, then please blow a hole in what public policy and patent illegality means. My lord was saying that we read that it's only when the court comes to the conclusion of patent illegality and public policy, because what was public policy was understood in a particular way, then comes ONGC, understands it in a different way. Because that set off from 2003 to 2025, a certain shell shock, the effects of which are still being felt. No matter how precisely my lords lay down the contours of any alleged exercise of power, because every party and their clever counsel will examine the boundaries of that My lords will first determine whether it's policy or not. Secondly, my lords, if it's restricted but curable, there will be again, every party will test as to what is curable or not. My lords have laid down principle upon principle in section 115 of the CPC, article 227, in the rare article, dare I say, article 136 of this constitution. Very restricted, only on these instances. How often are those principles followed, my lords? And the way there has been a boom of revisions and 227s, every 34 court would become like a revisional and appellate court. And rather than being expedited, it will retard and completely act contrary to the purpose behind the statute, which is speed. Where do we get this? This argument can't be taken at face value that because the court has the power to modify. My lords are not sitting in the final court. I repeat, my lords will just see the trial court, what the trial court will do. That trial court will modify, my lords, if it comes, even though when it is not required to be done, as a revisional court often indulges. And then, my lords, again, I repeat, that round of litigation starts, delaying arbitration. And here, my lords, again, I ask myself, in the last 30 years, save a few instances of individual injustices where, at best, the party is not remediless. The party can start an arbitration again. It may be expensive, but not being expensive is not a part of the problem of arbitration law, why it exists.
But what happens if the clerical error application under 33?
Yes, please.
A patent clerical or arithmetical error is not considered. It is dismissed by the arbitrator.
Well, there, the legislature has given a power to the court to step in and do something about it.
Where is that? 33.
33 minutes. One is 33.3. Within 30 days, you go, either you go to the court, go back to the arbitrator.
Yes.
If the arbitrator doesn't do it, then 34.4.
No,
But if this power exists, you go back. The question is, why should the court have this power?
I'm on clerical and arithmetical error.
Yes, Millis. Even under
Even
34.4.
that without 34.4 you can't do.
Millis,
All right.
it is not as a party is remediless. The question is, where is the remedy? Is that remedy before the court or before the arbitrator?
All right. Then time limit for challenging the award expires. It attains the status of a decree. Will 152 CPC be available at that stage or not? Because 152 is available only when it becomes a decree.
Millis, no, I would say no, because it doesn't become a decree. Under our act, unlike when it's made a rule of the court, our award does not become a decree.
No, it is enforceable as a decree.
Enforceable as a decree is different than being a decree. Because if there is a big difference between being enforceable as a decree and it being a decree. There are several judgments, if my lord wishes, we can cite them. It has always been understood that this is not a decree, because if it becomes a decree, then that problem, Mr. Pushkarna, comes into play. If it's a decree, then why is it not challengeable under section 96? It's not. It is not a decree, Millard. It is enforceable as a decree means an Amazon that has been held. It is not the law of our land that an arbitral award becomes a decree. It is very clear it is not.
As if it were a decree.
As if it were a decree. I mean, it's a deeming fiction for the purpose of an execution.
Even 152 can't be exercised.
May not be, Millard. Because these are timelines specifically.
So a 34 court without 34.4 cannot even correct an arithmetical or a clerical.
Millard, it may seem shocking.
It is shocking because
Maybe.
152 power
Yes,
is founded on actus curiae principle.
Well, actus curiae would be the tribunal. You go back to that tribunal which is acted in that way will correct it. It is, I repeat, not a case where the party is left remediless.
Does it correct it?
Well, it is not a case of ibi jus ibi remedium. That is, I suppose, the principle and my Lord Justice Vishwanathan is mentioning. There is very much a use, then there is very much a remedium, only the forum changes. The forum is not, well, this is a way to read this act which is logical. Now we're trying to find a better way, is not the way which is permissible. Sorry, I'll leave it at that. I think Mr. And the power of greater and lesser I've already pointed out. I have lots more, but I will follow the discipline. My lords has indicated they want to hear something. I will not. I will say nothing. Mr. Banerjee will argue.
How many of you are there from this side?
That's it.
May it please. My lord, there is something inherently appealing
in the argument of the petitioner, justice has been done. That's the first, my lord, point that certainly strikes a judge, that some injustice has been done and we must step in and solve the problem. This is, my lord, the first. There are three limbs to the argument. This is the first, my lord. Prima facie looks very appealing that some injustice is being done to me. Why should not the court after?
I will not go to that extent. Let me put it very clearly. Normally, as a court, there are two factors which play with us. One is to do justice, remedy the wrong. That's a factor.
That's the instinct, my lord. That should and is
No,
should be
but
the instinct.
if there is something wrong, let's
not fix the
remedy
problem.
wrong. Two is the courts like to normally assume a power because adjudicatory functions should not be curtailed.
So, my lord,
Not be unnecessarily curtailed until unless the statute specifically, expressly or by implication takes away that power.
So if I can summarize, not the other side, there are three limbs to the argument. One is, if there is some injustice, court's power should not be curtailed. The court ought to, as a matter of justice, step in and fix the problem. This is proposition one, my lord, which itself I will say something on. Proposition two is, if that be the case, then maybe 34 does not have the word vary or modification. However, in order to, my lord, support proposition one, I will persuade the bench to read it in one of three ways. One is adding words, one possible submission. Second is read it in 34(1) as part of setting aside. Second possible interpretation, according to me, my lord, the one which we will have to deal with. And third, forget 34(1), let us read it in 151. So this is point two, my lord. So point one is the court should have the power. Point two is, if the court has the power, these are one of three methods to do it. And three, realizing there's a problem with an untrammeled power, we realize there's a problem that there cannot be untrammeled variation. Guidelines have been suggested by various parties in various different ways. Possibly all of them, my lord, suiting their particular facts of the case. So everybody has their own, my lord, guideline, which perhaps will fit whatever factual background that particular individual has to place or perceived injustice. Lord, we are in a position, my lord, as the learned solicitor, my lord, we are not here on any particular set of facts. There are weighty arguments.
They are appearing for whom?
My lord, I am appearing for UNCITRAL, UNCCI, my lord. We have intervened as UNCITRAL. There are weighty arguments, my lord, which have been made on the other side, no doubt, my lord. But I will just, my lord, I think we should step back a little, because I think, my lord, we are proceeding on a bit of a misconception, which is this. My lord, we are treating this as an appeal from a judgment. In our mind, my lord, in the court's mind, that the thinking is that this is in some way an appeal from a decision by a inferior court. And my lord, there are at least, I'll attend them, my lord. My lord, there are at least 3 or 4 aspects which your lordships will consider before coming to the next question is, when can you attack an award? So, my lord, what is critical here is that an award is a baby of a private dispute. It is supposed to be out of the system. It is not supposed to be in the system. It is supposed to be out of the system. There are some implications here. My lord, an award is meant to be final and binding. Very important. It has to be final and binding. It is a consensual process. The moment the arbitrator finishes, his mandate gets over. Consent is over. Subject to, of course, correction and remand. The mandate is over under Article 32. the arbitral tribunal becomes functus officio. So, my lord, there are two policy aspects to an award which are not there in a lower court judgment. One is party autonomy, and I'll explain what is the relevance because I think this is crucial. And secondly, my lord, finality. You go into arbitration, nobody is forcing you, my lord. We have to proceed on the basis that nobody is forcing you to go to arbitration. It is a consensual process. The consequence of this, which has not been, my lord, probably appreciated by the other side, is an arbitrator can be wrong. An arbitrator can be wrong on the merits. He can be wrong on his appreciation of evidence. He can be wrong on the interpretation of law. But the law provides that because I have gone to somebody else other than the courts, courts will never tolerate a wrong order. But I have gone to somebody else, I will take that wrong decision because I want finality. I want a binding award. Therefore, my lord, 34 is restricted that it has to be at the level where there has to be patent illegality. So, my lord, the first point I want to make is please do not consider this as an simply, my lord, the intention is to keep it out of the courts. So, my lord, however much the instinct is to render justice, that justice has not to be rendered by the court, but that justice has to be rendered by the tribunal. Where your lordships are eager to fix the problem, the first proposition, the law provides and the statute provides that that is a remedy available to the tribunal. And opportunities are given to the tribunal in every stage. A lot award comes if there is clerical, etc., mistake. Then under the old act, section 15, which your lordship was referring to, it went to the court. But that is no longer the case. Section 33 is qua the tribunal. Please keep tribunal on one side, court on one side. 34(4), again an option. Surely the court could have intervened and said, I'm fixing the problem. No, the intention of the law is save the award, go back to the tribunal under 34(4). No, I'm not on the scope of 34(4). Go back to it. No, the third option. Why is setting aside so critical? Not because of essentially, why is modification not provided? Because of the problem of cherry picking. If you actually believe, if you really believe that that tribunal has messed it up, that it has not followed natural justice, or it has gone completely outside the jurisdiction, or it has made such an obvious patent blunder, why should you trust the tribunal's judgment on other points? I'll give a simple example, and it happens every day. 5 claims are made. 4 are rejected. 4 may be wrongly rejected because it may have been in appeal reversed, but 4 are wrongly rejected. There is no 34. The 5th claim is allowed, but even there the arbitrator commits a mistake, maybe on the overhead or A, B, C, D. If the court tweaks, let us say 5, what is the consequences? You are cherry picking one part of the award. The person who has actually lost, in a sense, because 4 of his 5 have been wrongly disallowed, has no remedy because he accepts the wrong judgment of the arbitrator. So, my lord, when your lordships come to a conclusion of pay, it's a very serious matter to set aside number. When your lordships come to the stage of patent illegality or the stage of setting aside cannot be the norm. Then, because of the seriousness of the matter, the set aside follows because your lordships have lost faith in the tribunal. It is not an appeal where your lordships will modify this, change this. So, this is my first.
If he has not challenged the rejection of the 4 claims.
My lord, he may have not been able to challenge the rejection of the 4 claims because even though it is wrong.
Why?
Because he can't.
Several degree. If he several claims.
No, I'm saying, my lord, it is, let us say it is connected. He cannot challenge those 4 wrong decisions because, my lord, unlike in a court, arbitration is not right or wrong. It may be a wrong decision on appreciation of evidence. It may be a wrong decision on appreciation of law. But because of the discipline of arbitration, you have accepted Mr. So-and-so as your arbitrator. You can't challenge under 34. That's the whole point. Otherwise, my lord, you have
That's why, my lord, the moment we bring.
Yeah, Mr. Banerjee, let's be very clear. There is a viewpoint, and in some countries that arbitration is a compromise adjudication, which has its own weight and disclaimer, but in the United States, there's a big move on that. Twice they have tried to introduce legislations to curtail arbitration. There are issues.
I can go.
But we are not going into that question.
Much further.
We are not going into that question. We leave it at that.
My lord,
We leave it at that. But the fact of the matter is, where we are not saying interfere and modify. We are saying first you will have to come to the conclusion that the award has to be set aside. If you come to the conclusion that the award has to be set aside, then in case the defects are curable, either in terms when a court can interfere and cure them, or then go under 34(4). In fact, what you are arguing is contrary to 34(4).
No, I'll just come.
Because once you're saying that once you've lost, that the arbitral tribunal has not done something wrong or has done something wrong, sending it back again under 34(4) will serve no purpose.
No,
You're yourself arguing that.
Let me, my lord, come to
You yourself argued to that extent.
my lord, my first proposition is this.
So we are neither tinkering with the clauses on which the award can be, the argument of the other side is do not tinker with the clauses under which the award can be set aside. Yes, if you come to the conclusion that the award can be set aside, then you have two options, 34(4), or if it is a curable defect by the court itself, because then you do it.
May I just, my lord, respond to that?
So you please confine yourself to that.
My lord, I'm responding in legal and practical terms. There are 5 separate concepts here as to how an award can be attacked. My lord, I'll hand over my note. No? One is the power to confirm an award. Under our law, under the 1940 Act, there was a power to make an award rule of the court. Under some statutes, there is power to confirm an award. Model law, and we do not have there is no role of the court in confirming an award. The role is a negative role. The role of positively affirming, confirming an award does not exist either in the model law or in the 1996 Act.
Except part 2, the recognition part, maybe.
Recognition is also, my lord, not confirming an award. Recognition is a completely separate concept. My lord, the second concept is of variation. I am not using the word modification, my lord, because modification can mean many things to many people. So, my lord, the word which is used is variation internationally. Variation means that you affect in some way the relief, or you modify and enter and cross the Lakshman Rekha into the merit. So, my lord, there is variation. That is one second concept. My lord, the third concept which your lordship has is correcting an award. Correcting an award, which was earlier there, my lord, in section 16 of the Act, is now placed in Article 33, which is our section 33, which in fact is important because it gives power to the tribunal, which was earlier there before the court. Now, my lord, all these concepts are relatively clear. Now we come, my lord, to the fourth concept of remission. Remission also has a particular meaning. My lord, remission is when the court sends the matter back to the tribunal. That's all that remission means. 34(4) is where you send the award back to the tribunal. I'll hand over my note. We have quoted some portions of the ancestral model law. Remission is remand to under Article 34(4). Now, my lord, very interestingly regarding remission, unlike the previous law, there's commentary on this, remission was a standalone power of the court. You can remit. Here, advisedly, and the learned solicitor has read it out, remission is couched specifically within the set aside provision. 34.4 is placed, well, Lord, remission could have been a separate power like in the UK, etc., where you simply send it back with some directions or otherwise, etc., and then the court, whatever happens, there are statutory provisions. Remission means within section 34.4, I am not going into the scope of remission because there are at least 3 judgments of your court, of your lordship's court, which have explained remission. There is also a court of appeal judgment of the Singapore court, which has also explained remission. So, my lord, I am not going into remission. Your lordships have settled the law on article 34.4. Subject to what is being said, my lord, there are the IPA is the latest judgment. It is there. The idea again, my lord, one has to look at this. Idea again is the legislature intends that it is the tribunal in which you have faith, which is given the power to cure the defect. The legislature did not intend that this power of remission is to be exercised by the court itself in the first instance. It did not, my lord. It said that if you find it appropriate, you, on an application of a party, again, my lord, not suo motu, on an application of a party, adjourn the matter. First send it back, then adjourn the matter. That's the language. So that if the curable defect is cured, your set aside ends. You don't need to bother with a set aside if the defect is cured when it comes back to you. Again, my lord, that's the logic. Now, my lord, we come to the most important aspect of annulment and set aside, and whether annulment and set aside encompasses within it the concept of variation. Well, I'm very careful to use the word variation because modification, again, we don't know where it stands. Does the concept of setting aside encompass the question of variation? Well, Lord, there are some passages. I'll just read first, if your lordships permit me. Before I come to this aspect, I will read 2 paragraphs from Redfern and Hunter, my lord, which is applicable across the board. It is a very, very pithy paragraph, which perhaps your lordships will understand where I'm coming from. Please see page 150 of volume 4. It's a very interesting paragraph. I think it says a lot. Yeah, we can hand over that. Well, Lord, we can hand over this. I'll just hand over the submissions. Okay. Yeah. Here, well, Lord, it starts with the sentence. It's the chapter headed Challenge of Arbitral Awards. I wonder if your lordships have got it. It starts with the sentence, no one likes losing. So it is not surprising that when a client is disappointed with an arbitral award, the first question the lawyer is asked, how can I appeal? As is so often the case when a lawyer is asked a question, the answer is, it depends. First, it depends on whether the relevant rules of arbitration establish any internal appeal procedure, as is the case in certain maritime and commodity arbitration systems. You know, this is like Central Trade, etc. There is an internal appellate procedure. It is noteworthy that most arbitration rules do not provide for such an appeal. Indeed, most institutional rules provide unequivocally that an arbitral award is final and binding. Well, this is our section 35. These are not intended to be empty words. One of the advantages of arbitration is that it is intended to result in the final determination of the disputes between the parties. If the parties want a compromise solution to be proposed, they should opt for mediation. If they are prepared to fight the case to the highest court in the land, they should opt for litigation. By choosing arbitration, the parties choose in principle finality. An arbitral award is not intended, and I rely on this, my lord, not intended to be a mere proposal as to how dispute might be resolved, nor is it intended to be the first step on a ladder of appeal through national courts. This is something your lordships will keep in mind while considering whether the power of modification should be exercised by the court. So, my lord, one aspect of this is, one policy aspect of arbitration is finality. And I'll show, my lord, that is what our 5-judge bench in Raipur, Chokamal, has also said. Finality is one major aspect. Then, my lord, to the losing at disadvantage may seem retrospect very opposite. Laws of many countries reflect the policy of New York Convention. What has been described pro-enforcement bias means that while it may be possible to challenge an arbitral award, available options are likely to be limited and intentionally so. So, my lord, I'm not reading 10.04 and 10.05 for the moment. Please come to 10.06. The purpose of challenging an award before a national court at the seat of arbitration is to have that court declare all or part of the award null and void. If an award is set aside or annulled by the relevant...
Just 1 minute. Whole or part of the award null and void?
Yes, yes, part of the award can be null and void. Can be partial set aside, my lord, is well recognized. There's no dispute. That is, my lord, my learned friend will address your lordship. Partial set aside is effectively, my lord, partial annul. No difference. Not only by the courts of the seat, but also by national court. This is because under such New York Convention model law, competent court may refuse to grant recognition and enforcement of an award, which has been set aside by court of the seat of arbitration. Important to note that following complete annulment, the claimant can commence proceedings because the award simply does not exist. That is, status quo ante is restored. This was mentioned, my lord, in the Hakim judgment. The reviewing court cannot alter the terms of an award, nor can it decide the dispute based on its own vision of the merits. Lordships will consider whether, by granting to your lordships the power of modification, is the court going down this path? Unless the reviewing court has the power to remit the fault to the original tribunal, as in England, a new submission of the dispute to arbitration after annulment has to be undertaken by commencement of new arbitration. So, my lord, this is 10.6, which has been set out in Hakim. But what is more important, my lord, is 10.1 and 10.2, which is the aspect of finality, which is a crucial policy aspect which your lordships will consider. Now, my lord, I want to show one judgment on what annulment means, because it's very important, my lord, to understand what annulment means. We have all been talking about the words, my lord, internationally used are set aside, annulment, vacatur. What does this mean? And, my lord, we have there are, of course, my lord, Singapore judgments. I will meet the point specifically lays that Singapore law has a prohibition. I will show, my lord, that is probably not a correct interpretation. I'll show that. But I want to show your lordships first the Topfer judgment. Page 185. 3 very interesting paragraphs.
Page
185. The other side had cited modern laminators, learned single judge Justice Endlaw. Obviously, my lord, with the passage of time in the division bench, he perhaps revised maybe he was wiser is all I can say. But this is my lord, there are 3 paragraphs here which have some resonance. Please see paragraph, please note the paragraph 7, 8, 9, 11 and 14. I will only read 7, 8 and 9. Annulment is intended to be a faster and less, arbitration is intended to be a faster and less expensive alternative to the courts. If this is one motivation expectation, then the finality of the arbitration award is very important. The remedy provided in 34 against an arbitral award is in no sense an appeal. The legislative intent in 34 was to make the result of the annulment procedure prescribed therein potentially different from that of an appeal. In appeal, the decision under review not only may be confirmed, but may also be modified. In annulment, on the other hand, the decision under review may either be invalidated in whole or in part, or be left to stand if the plea for annulment is rejected. Annulment operates to negate a decision in whole or in part, thereby depriving the portion negated of legal force and returning the parties as to that portion.
The unilateral model uses term annulment or setting aside.
My lord, I put it in my... The ancestral model in English uses setting aside, in French.
No, in the as originally drafted.
Setting aside, and in the French, which is the model law, uses annulment. Both are used interchangeably. I put the French law also. This is the same, some,
Oh, but the unilateral, there's a French
official version,
official version of unilateral which uses the term annulment.
annulment.
But annulment in French may mean something different from.
It means the same, Mullah. I have French judgments also, but I'm not going to, but the word which is used is an annulment.
No, but the French phrase annulment or the word for annulment.
Is identical. Mullah.
Look,
I
like if I have to find a Hindi word,
sorry.
if I have to find a Hindi word for setting aside, it may be wider, it may be narrower.
Mullah, the general understanding of setting aside or annulment or vacation, the other word which is used internationally is vacator. You vacate the award. You obliterate the award. You quash the award. Mullah, may I just, in annulment, on the other hand, the decision and the review may be either invalidated in whole or in part or be left to stand at the plea for annulment.
What was the issue over here?
Mullah, 34 interference in appeal. May I just,
But they were not going to the question of.
modification, yes, modification was also argued. Mullah, please just see these 3 paragraphs in order to understand, Mullah, what is this concept? In whole or in part, thereby depriving the portion negated of legal force and returning the parties as to that portion to their original litigating position. Annulment can void when appeal can modify. Section 34 is found to provide for annulment only on the grounds affecting legitimacy of the process of decision as distinct from the substantive correctness of the contents of the decision. A remedy of appeal focuses both on the legitimacy of the process and the substantive correctness. Annulment in the case of arbitration, not on the correctness of the decision, rather more narrowly considers whether, regardless of errors in application of law or determination of fact, the decision resulted from a legitimate process. In the case of arbitration, the parties to the agreement create an entirely different situation, regardless of how complex simple dispute resolution mechanism. They almost always agree that the resultant award will be final and binding on them. In other words, regardless of whether there are errors of application or ascertainment fact, parties agree that the award will be regarded as substantively correct. Yet, though the content of the award is thus final, parties may still challenge the legitimacy of the decision-making process leading to the award. In essence, parties are always free to argue, not bound by a given award, because what was labeled an award is the result of an illegitimate process. This is the core of the notion of annulment. In a sense, annulment is all that doctrinally survives the parties' agreement.
Then patent illegality being introduced in India.
My lord, patent illegality.
One, Mr. Banerjee. Once patent illegality being introduced in India, will it not, will the unilateral model still be completely applicable?
Patent illegality has now been introduced. It was first spelled out by the court as an aspect
So
of
will it not impact the whole
I will come
to
to
that extent as well as domestic
separately on 34(2)(a) as to, my lord, one argument that
No, I'm not on that. That's a separate argument. Complete reliance, therefore, on unilateral model may not be appropriate once the Indian legislature has brought in the concept of patent illegality.
my lord, for patent, this is what was argued by Mr. Kambata, that modification should be restricted to cases of patent illegality. There is a reason he argued that, and my lord, there is a consequence if modification is to be read into the other provisions. There is some, my lord, I'll come to that. But my lord, even a case of patent illegality is not a correction of merits. It's not a correction of merits.
We are not saying that.
And
Neither has anybody argued that.
when you
in
have
case of
patent
an India.
illegality, it is so extreme a situation that the legitimacy of the process and the fact that it is a legitimate award does not pass your lordship's muster. If you are saying somebody has done something not illegal, but patently illegal, then how can you have faith in that arbitral tribunal? How can you then tinker with it? Then that man has to go. If you genuinely believe that he's done something wrong, which is so illegal that it shocks the conscience and it is at the root of the matter, then he should go. Where's the question then of, my lord, saying, all right, this is okay, that's not okay. No, that's what I'm on. Please see para 11. Just half that paragraph, I'll leave it. 14, your lordships will see as to the what is being said. This was Arbitration in 1940 Act could not achieve the savings in time and money for which it was enacted, merely became a first step in lengthy litigation. Reference in this regard can be made to paragraph 35 Balfour. It was to get over that said malady, a law was sought to be overhauled, while under the old Act, award was unenforceable till made rule of the court, for which it had to pass various tests laid down therein. General power authority was vested in the court to modify it. All this was removed in the new Act. New Act not only made the award executable as decree after the time of preferring objection, respect thereto had expired, without requiring to necessarily be made law, but also did away with the condemnation of delay in filing objection. Reason, purpose being expediency. The grounds on which objections could be filed are also such, if it made out, this I would respectfully submit would also apply to patent AL. The only consequence thereof would be setting aside the award. It is for this reason that under the new Act, there is no power to the court to modify the award or to remit the award, etc., subject to 34 under the old Act. So, my lord, then I continue. I will not continue reading. The lordship may just note para 14. So, my lord, the second limb of my submission. First limb was that we are not looking at a judgment. We are looking at an award. An award has some particular features. My lord, the second limb of my argument was that there are conceptually 4 or 5 aspects. Annulment is different. Modification, variation is different. Correction is different. Remission is different. Confirmation is different. All are different. They are all well understood concepts. So, my lord, whether annulment, whether variation of award can be fitted in to the set aside. That's, my lord, my the third proposition, which is I am not even answering, my lord, question the 3 points. The first is adding words, my lord, that has already been addressed. The third point, which is quite alarming, my lord, is the bringing in of 151. There are some significant consequences. If you bring in 151, you bring in 151, you automatically bring in 115, you automatically bring in Order 41, Rule 22. That reference.
No, that's not been argued. What has been said, 151 is not really that way. What has been said is, once you give a power, even on 34, there will be some ancillary and residual powers which flow with every forum. And that's the objective of any procedural section. No procedural enactment can visualize and deal with all sorts of situations.
So,
that's why, except in Evidence Act, we always say everything is permitted until unless it's expressly barred or impliedly barred. You don't have to look at the provisions of the CPC or the CRPC to find out whether a particular procedure is permitted or particular way.
And I'll come to the 7 judges on that. Our Act flips it on the head. Our Act, particularly the way it has been understood, also where lordships were there in the 7 judges, that our Act says, and the 7 judges do say, that Arbitration Act is a complete code.
No, that's
that
fine.
portion has not been written.
Irrespective of the fact that CPC is a complete code, these are the principles which are applicable to procedural laws.
I will go.
We are dealing with both 2 aspects, procedural law as well as substantive law in arbitration.
My lord, may I just put it in this way? One argument could be you read into section 36, the word phrase set aside, you read into the word vary. This is one separate argument.
And it also says this. It also says this CPC and Evidence Act are not applicable to arbitration.
My lord, in fact, very interestingly, under the old Act, the other side relied on ITI. ITI has been doubted in MTNL. And the reason for that doubt is
that we have understood that because there was an appellate remedy then provided.
And, my lord, there was a specific provision under the old Act. Your lordships will note this. There was a specific provision in the old Act incorporating the CPC. Specifically, that which is not there. There were, I think, 41, section 41, specifically bringing in CPC. So, my lord, we have to get out of that, should I say, my lord, CPC mindset for a moment. So, my lord, the question which is put is that why should annulment not include variation? This is the argument. This is the highest that it can be put. Why should it not include? My lord, one, I have already argued, basis, this Topfer judgment, and there are a couple of Singapore judgments which I will show. that these are two different concepts. Variation is certainly possible if you have the power to confirm, or in an appeal, then of course you have the power to vary. But in an annulment, it is a negative power. The difference between annulment and variation is where the Lakshman Rekha has to do. Annulment is a negative power. What the court does is, and the language is simple, you don't like the award does not pass muster, you set it aside, you stop. Why? Because the next step is always with the initial forum which you contracted to. The moment you cross the Lakshman Rekha, then you are wearing a different hat. You are wearing the hat of virtually appeal. Because then your substitute, that is the sentence which I read in Redfern and Hunter, you are substituting, you, my lords, will be substituting your own vision of the merits into the award. So, my lord, there is a fundamental distinction between annulment and my lord, it is extremely difficult for somebody who wants to do justice to hold back. And sometimes, my lord, it is necessary to hold back in order to do overall justice. And I will make it good. Now, my lord, one argument which was put is squarely by the other side. I have had the benefit, my lord, now your lordships have transcript. So I went and read the transcript as to exactly what was argued. My lord, what is argued is, why look at the Singapore law? They have a prohibition. We don't have a prohibition. The law there is different. The law here is different. That was argued by Mr. Khambata and also Mr. Rai. And my lord, the section that was pointed out was section 47 of the Domestic Act. So my lord, here is the problem. Our act, as my lords correctly put to me, considers both international commercial arbitration and what I would call purely domestic arbitration in part 1. My lords have 2(1)(f), both are there. 34 makes a slight distinction that 34(2)(a), which has been introduced, is limited only to domestic awards. We do not have two legislations. Singapore has two legislations. My lord, the first legislation that it has is the International Arbitration Act of 1994, which is the model law, which is the, by and large, the sections that we have in part 1. So, my lord, if we are to compare like to like, we will be comparing IAA 1994 with our part 1. The sections which are being relied on to say that there is a prohibition 47 on the court. Well, not again, this problem comes court, tribunal. The prohibition sections on the court are not in IA 1994. It is in the Arbitration Act. It's all there in the note. In 2001, 47, 48, and 49 of the Domestic Act says you cannot vary except in such situations. So, my lord, it is not a prohibition in that sense. It is a almost, if you read all three, it's almost enabling. But that only applies to purely domestic arbitration where the legislature there has deviated from the model law. We have, my lord, in fact, we had recommended that there should be separate acts. It has not been done. We have only one act that has innumerable problems. But today we have one act, and today whatever interpretation your lordships give on section 34 will equally impact, this is very, very critical, will equally impact ICA situated in Delhi as also domestic arbitration. It will impact clearly. And it will have a very serious, my lord, impact across the board. My lord, so far as domestic awards are concerned, and those two judgments, my lord, AK and ALC, and the other judgment shown by the learned solicitor, I will show.
Please try and conclude by 3 o'clock or 2:30, 3 o'clock. Then we'll hear the, sorry.
Please, I'll come to that. कुछ लगाएंगे सर
Yes, Benedict.
Yes, please. Lord, just to summarize, I had summed up the submissions of the other side in three propositions. My Lord, first, that there are compelling policy reasons as to why this court should have the power. And I submitted, my Lord, there are equally compelling policy reasons why this power should not be bestowed on the court. That was one submission. My Lord, the second submission, if your lordships were minded to read in such a power, the other side has argued on various different bases, adding words to statute 151, and my lord, most importantly, that it should be read into the phrase set aside. I was answering that second point. The third point, my lord, is as regards guidelines. So, my lord, that is how I understood their case, and that is what we are replying to. My lord, so far as the second point is concerned, I'll come back to the first point because there's something there which might appeal to my lord. I'm taking the second point first. The submission is that within the word setting aside, you can fit in the phrase variation, modification, whatever. Of course, subject to guardrails. But my submission was that this may not be strictly accurate because annulment is a creature different from variation. That was the submission that your lordships will consider or not consider. But when this argument was made, the response of the other, and the learned solicitor had mentioned, your lordships may recollect, two Singapore judgments. Amongst the many judgments mentioned, not very comprehensive note by the learned solicitor general, two judgments he had specifically mentioned. And the response from the other side, your lordships will know, unfortunately, my lord, we have something called Teres, which tells us exactly what we have argued. So I went back and my lord looked at it. The response from the other side was, Singapore law is different. Section 47 of the Act provides for an express prohibition. There is no such equivalent provision in our Act. Therefore, absent such specific prohibition, it can be implied. That was the submission. I'm meeting that submission because that's a important submission. Because, my lord, we are looking at some degree of consistency across jurisdictions. My lord, may first see that there are two acts in Singapore. There is the IAA of 1994. And your lordship will just see volume 4 at 301 at 304. It's actually a very short act. No? We've extracted some portions, not the whole act, my lord, has been filed by the learned solicitor. So, my lord, we've just extracted some portions. 301 this is the international arbitration, which is effectively, if your lordship sees at page 304, based on the model and covers international commercial arbitration. Now, my lord, here there is effectively one provision on set aside, which is section 24 at page 305, which follows 34.1 and adds corruption and natural justice.
Yes, volume 4.
My lord, we have filed a common compilation. So volume 1 has been renamed volume 4. (301) is the International Act. This covers, my lord, international commercial arbitration at page 301. And, my lord, if your lordship sees at page 304, this is basically based on the model law. At the top of the, my lord, the act is to make provision for conduct of international commercial arbitration based on model law. So the Singapore legislature adopted a separate act for the model law, and the only section which is vaguely relevant, my lord, is 305.
No, but to be very frank, as far as international arbitration is concerned, they are not concerned because this will be part of the substantive law.
My lord, your lordships are
But let me put it this way. As far as transporter disputes are concerned, there is a lot of controversy as to the law of arbitration which will be applicable. And there are different opinions, even in France, Britain, and they are following different.
I will place our,
We need not go into that because it's not relevant.
I am
over here.
not place.
Only reason why I mentioned that was, in order to find out, we have to go to the substantive law of that country, whether there is express bar over there or not.
I am not on substantive law or my lord, different laws. My lord, I am on a simple point that the Singapore court has two different laws.
One is for international arbitration
and one for domestic.
Correct.
Both are laws applicable to my lord, matters where the seat is in Singapore. So when the seat is in Singapore, either you apply one law or you apply the other law. We don't have this distinction. My lord, the other act, which is the Domestic Act, your lordship, is 291.
This, as far as international arbitration is concerned, there is no specific bar in this.
In the International Act.
In this, there is no specific. The provision 41 is not.
47.
47 is not part of the international.
Correct. 47, which is being relied on, my lord,
Is for the domestic law.
is at page 296 of the same volume.
And rightly so, because this issue may not arise in international arbitration. It may.
No, my lord, it squarely arises. And it has massive implications. which I will show.
Because I'll tell you the reason.
My lord, I'll come to.
Very few, there will be the international arbitration which is taking place in Singapore is between two other countries, not with regard to the residents of Singapore.
I am on a.
Number one. Number two, also, most of the cases when you go for enforcement, you'll be going to the enforcement to the country where the judgment debtor or the loser is.
This is a larger issue. My lord, I am only meeting a specific limited argument.
Only just to, Lord, since Lord, I argued happy explanation. There are three laws which are in contemplation whenever, my lord, we have arbitration.
Correct.
Lord, law governing arbitration agreement,
Correct.
which would in this case, my lord, would be Indian Arbitration Act. In Singapore, it can be Singapore Arbitration Act. Second, the law governing contract. It can be Indian Contract Act also in a London seated arbitration. So Arbitration Act of London would apply, but the law governing the contract would be Indian law.
Correct.
And third is Curial law. Curial law would mean, my lord, there are some, my lord, institutions, they have unilateral rules.
No, that's the procedural law.
Yes, Curial means procedural. Curial
law.
means procedure.
Procedure of arbitration.
Substantive can be Indian Contract Act. In a matter of
petroleum,
can be Indian Petroleum Act.
Mr. Mehta, we are aware of all this.
Meeting
But as far as international, the law relating to international arbitration is concerned, probably, I'm not giving a affirmative yes or no, subject to exceptions. It refers to the procedural part. So it will not refer to the substantive part or the law of arbitration, which is applicable in that.
May I just read what has been argued on the other side? Mere non-reference at the highest or express reference to power of vary or modify does not mean power cannot be read into section 34 because there is no prohibition. And we see, for example, the example of Singapore. My learned friend, the solicitor, cited section 47 in his written submission at page 23, where there is an express prohibition. There is no such provision here. This, I am meeting this argument. Oh Lord, my argument, counter argument is simple. This express prohibition, which is being relied on by the other side, is section 47, 48, and 49 of the domestic law, which is at page 296. So, my lord, it has, this is not there in the International Act. Right. Now, my lord, what is the consequence of that? I want to mention, my lord, this has been explained in so many words in a judgment cited by in the written submissions of the learned solicitor. Please see that, my lord. This is a written submission filed right at the beginning. Now, coming to that. Have page 9, paragraph 93, page 76. May I read para 93?
Yes, please.
At page 76. The Honorable High Court of Singapore in CAI versus CAJ agreed with the defendant's submission that under the IAA and the model law, the court did not have the power to vary an arbitral award, held that the court's power limited to either setting aside, where appropriate, to suspend the setting aside proceedings, remit the award for the tribunal's decision under 34. Relevant paragraphs are produced below. With regard to the defendant's submission under IAA and model law, court does not have the power to vary an arbitration award. I agree. Court's powers in setting aside applications circumscribed by Article 5 of the model law provides that matters governed by this law, no court shall intervene except so. Then, my lord, 238, AKN and ALC, this is the Court of Appeal judgment, Justice Sundaresh Menon's judgment, which also is referred to by the learned solicitor. Other appeals, the Court of Appeal construed Article 5 of the model law and held at effect of 5 is to confine the power of the court to intervene in an arbitration in those instances which are provided for in the model law, exclude any general or residual powers arising from sources other than the model law. Article 5 has been explained as guaranteeing the reader and user that he will find all instances of possible court intervention in the model law. There is no mention of the court's power to vary or amend an arbitral award in the model law or in any other section of IA. This is in contradiction to Section 48(8)(b) of the Arbitration Act, which expressly provides the court with the power to vary the award. Furthermore, 19(b)(2) makes it clear that it is only the arbitral tribunal which has the power to vary, amend, correct, review under Articles 33 and 31. As such, it is clear under IA does not have the power. Courts limited to either setting aside, where appropriate, suspend. So this is, my lord, the view that I will commend, my lord. And this view has been is in respect of the IA. Now, my lord, how does this...
Without interrupting you, going back to your compilation, page 296.
Right.
Just back to this in your submission.
296, yes, my lord.
48 is the original quote for setting aside.
296, my lord.
Bottom.
47 and 48
48 is the setting aside quote.
are setting aside quote.
Now, there is an appeal provided.
Yes.
In the appeal in subclause 8.
Yes.
CD.
For domestic. Yes, absolutely. My lord, that's the difference.
Just one.
My lord is absolutely right. This is a conscious decision that for domestic, you will have this sort of right of appeal. In fact, my lord, we have appeal, variation. My lord, in fact, one, and I put it in my written submission, the problem is not the remedy. The problem is in India, the right to challenge has to be wider in domestic matters. But that's not the scope of this, my lord. 48 should be there in our law for domestic arbitration. It is not. My lord, sir, the short point is this. There are two separate regimes in Singapore. One permits modification, one does not permit modification. Our fortune or misfortune is that in our part one of our,
One specifically bars modification, one impliedly bars modification.
my lord, one doesn't specifically bar modification. My lord, your lordship is reading 47. In fact, 48, 49 permits the modification. 47 has to be read with 48, 49, 50. It is not an express bar. It is as except, then gives 3 grounds for modification and appeal, which, my lord, we should actually have here. We should have a wider scope of challenge in our Indian situation. That's another matter, bro. So, my lord, the International Arbitration Act does not contemplate modification, is what the judgment says there. Now, my lord, our act has this, sorry to say, khichdi. My lord, our act is, and I agree with Mr. Datar, my lord, we have copied, cut and pasted ICA law into our domestic act. For whatever reasons happened in 95, my lord, your lordship may know, I have some idea as to why it happened. It has happened. Now, our act, if your lordship just sees the act, covers both in part one. So part one covers a situation of an international commercial arbitration as also other than international commercial arbitration. So sometimes, you know, there's some confusion between domestic foreign. If the arbitration is seated, let us say in Delhi, it could be other than, which is purely domestic, or it could be an ICA. That is clear, my lord, from 21F, and that is also clear from section 34. Now, if that be the case, my lord, 34 will apply, subject to 2A, will apply insofar as ICA is concerned. Now, the question which comes is, can an ICA award delivered in Delhi, may I put it differently, ought an ICA award delivered in Delhi be subject to modification? That's, my lord, one question which squarely arises. Whether a domestic award should be subject to the amendment, my lord, I'll come to. So let us take a case, my lord, supposing your lordship do not accept the arguments and say, yes, an arbitration under 34.1, my lord, 34.1 setting aside includes modification. And supposing, my lord, an award such as an ICA is modified. What is the practical and legal consequence? I will, my lord, demonstrate, and I've put it in my note clearly. My lord, such an example is there before my lords in the Vedanta matter. In Vedanta, my lord, it was a foreign party, Chinese party against Vedanta. The award was upheld by single judge. Award was upheld by division bench of Delhi High Court. The Supreme Court tweaked the interest. There was some portion where the interest was tweaked. For whatever power, my lord, I'm not going on the power. Now, my lord, the foreign party, there is a problem here. There is a problem, my lord, in the Delhi High Court execution. There have already been 3 rounds as to how much of the award has been modified by the judgment. That's a separate point. Now, my lord, hypothetically, please take that award. That's an ICA award made in India. Take that award and try and enforce it against Vedanta in London. My lord, it will fail on a very simple point. It will fail because what are you enforcing? Are you enforcing the award? The problem, there's a judgment. Are you enforcing the judgment, or are you enforcing the award is modified by the judgment? My lord, this is a problem which is being statutorily addressed by at least 3 jurisdictions, because this is an international problem. And they have brought in specific statutory provision to get over this. So, moment your lordships judicially agree that an ICA has to be modified, it will cease to be enforceable under the New York Convention, absent the requisite backup legislation. So that will be the inevitable consequence. So therefore, my lord, the question of having ICAs in India will go, because the main benefit of the New York Convention of enforcement abroad an Indian party may want to enforce abroad, this may have been a foreign party, will go. And my lord, 3 sections.
So suppose 34,
So,
4A is applied and there is a severance.
my lord,
In a
34
ICA,
to
International Commercial Arbitration, India seated,
severed,
award passed,
severed.
severed under the non-arbitrability clause. We'll just go to that, 34.
No problem, my lord.
That award
That's
also will have the
that
same
portion
problem.
is set aside, it cannot be enforced.
That award will also.
Because of my lord 5(2)(e), that portion of the award cannot be enforced because of 5(2)(e). No difficulty.
No, if that is so, if in the form of interest, which doesn't affect the integrality of the
My
award,
lord, I will show 3 provisions of 3 acts.
doesn't any way impinge on your contentions, evidence. It is a 31(7) power, exercised by the arbitrator.
Let us take that example. I am grateful.
That will be a money added to the awarded money.
Let us take that example.
31(7).
My lord, exact example in Vedanta. Please take that example. The matter comes up, it's an ICA, award has been modified. My lord, award has been modified on what basis? Patent illegality is not available. So it will have to be public policy, or it may be, my lord, 142, whatever. Award is modified. My lord, let's not question why the award is modified or award is modified. Now I take that award as modified to enforce it. Now, my lord, there are 3 provisions which I want to show to my lords, which are required under our statute to make sure. So, my lord, modification has to be legislatively brought in and modification has to be legislatively protected. Please see the provision, my lord. The learned solicitor has put it in his compilation. I'll show 3 of them immediately. First, your lordship will see 289 in England, volume 4. There are specific provisions which deal with this problem. Today, by judicially modifying an award, you will render the enforceability of any ICA vulnerable outside India. Nobody will bother coming to arbitrate ICA disputes in a Delhi seat or a Bombay seat because they will not be comfortable knowing that it cannot be enforced. That's the submission. Please see 71. India seat. So you will have a situation inevitably where your ICA is inconsistent with the international.
Is it as far as Singapore you have pointed out?
No, I am not on Singapore. I am on here.
1 minute, please.
Please see 71.
1 minute, please. As far as Singapore is concerned, also, as far as domestic arbitration is concerned, if the seat is of arbitration is in Singapore, domestic will apply or then international will apply? If the seat is in Singapore.
International will apply if it's an international arbitration.
But even if involving a.
Both are, yes.
Even if one party is a Singapore party?
Yes, my lord.
Right.
One party. Yes, same here, my lord.
1 minute, please. But as far as, say in a given case, in England, where the domestic law makes the variation possible.
Yes, my lord.
It will equally apply to foreign arbitration.
Yes, my lord.
Correct? Because the law of arbitration may be.
It will apply to an ICA. Let us say ICA.
The law of arbitration.
Yes.
Maybe that of England.
No dispute.
In that case, will you say the same logic will apply? Your argument?
Yes, the same logic will apply, and the reason to get over that.
Therefore, your reasoning that in case we interpret it this way, it will defeat or it will negate it will make India an unattractive arbitration destination is flawed. Or if that is so, then Britain will not be, England will not be a favored.
Short reply, my lord. England, your lordship has taken the case of England. 71(2) has been specifically enacted to get over this problem. My lord, there are specific provisions which deem an judgment to be an award. There are problems with that. There are deeming fictions which have been brought in by statute to protect such a modification. That is not there.
In case of international law.
Yes. They have. Please see first 71(2). I want to show my lord 2 or 3 other provisions. So, my lord, even clearer. England has 71(2) where the award is varied. The variation has.
Which page are you on?
289 of volume 4. there are specific provisions which rescues this problem.
Okay. Yes.
71(2), my lord, where the order is varied, the variation has effect as part of the tribunal's award. So it is deemed to be part of the tribunal's award. My lord, even more clear provision, and I'm grateful, my lord, to the learned solicitor to have pointed it out, is in his written submissions. Page 28. Page 28 at 29, New Zealand. 28, New Zealand, 28, section 5(7), where the award of an arbitral tribunal is varied on an appeal under this clause, the award as varied shall have effect except for the purpose of this clause, as if it was the award of the arbitral tribunal, and the party relying on the award or applying for its enforcement under Article so and so shall supply the duly authenticated original order of the High Court, varying the award or a duly. Your Lordship knows under the New York Convention, you have to supply a certified copy of the award. So
But then will the same principle not apply in case the
No,
award
we
is
don't have-
segregated? In case the award is segregated and portion of the award is set aside? Same
If
principle
it
will
is
apply.
set aside, that cannot be enforced.
So if
The
if-
balance-
one minute, just one. To that extent, the award which is modified cannot be then applied abroad?
Because, my lord, there is a defense. I'm sorry, my lord. There is a defense under 5(1)(e) of the New York Convention, which says when part of an award is set aside, you can object. So, my lord, it's a defense. What your lordship is saying, partial annulment. My lord, one part is set aside. I file my award. The other side in 5(1)(e) will say defense, that by the way, this portion cannot be enforced in England because it has been set aside by the state court. So, my lord, there is an inbuilt remedy in the New York Convention. Today, if your lordships are going to modify, say, interest, the consequence is serious. My lord, there are, I can produce, my lord, live examples. I didn't realize this was, that there will be serious problem of enforceability of an ICA. That's the reality, my lord. And that is why, if we wish to do it, and maybe we should, my lord, if we wish to do it, we should do it through carefully calibrated, targeted legislation to make sure that our award is enforceable.
So it's so difficult to manage, Mr.
Sorry,
Bhatt.
man?
It's not that difficult. You see, even in part 2,
My lord, we are not in part 2.
I'm just taking, for example, suppose there is an enforcement proceeding. The party says in the seat there is a challenge.
Yes.
There is a power to give security and have the matter adjourned.
5(2).
By 48(3)(a).
5(2).
Now,
Same.
Now, suppose the award proceedings result in modification of interest.
Correct.
What is the difficulty for the enforcing court?
One of the enforcement
The
court will
award
say,
with the-
as it has said, it's not an award. This is the standard defense maintained. It's not an award. It's an award modified by a judgment. Until you have that legislative fiction which says that the judgment is deemed to be an award, it's a judgment. It is good enough to resist. It is good enough to resist. You are not enforcing, under the New York Convention, you are enforcing an award for which you have to, under even our provision, give a certified copy of the arbitration agreement and a certified copy of the award. That's it. Now you are giving certified copy of the agreement, certified copy of the award, and the judgment modifying.
Chief Justice's query on severance.
Sorry, Manoj.
Severance matters.
Manoj, severance is very, very simple, Manoj. I am putting in the award. The defense is available under Manoj, section 48. The defense is available that part of the award has been set aside. So I go with my award. I go with my full award, but the other country will not recognize the full award because the other party will put up a legitimate defense. So at that stage, the defense will be put up that part is gone, annulled, set aside. Don't even look at it. So, my lord, there are practical difficulties which have across the board repercussions when this tweaking takes place. And while there may be good reason to do it, This may not be the forum to do it. That's all we are saying. We are not saying that this should not be done. I was part of that Vishwanathan committee. We also recommended that something should be done. That's a call. So this is one aspect I wanted to bring to your lordship's notice, that this is a live problem which will arise in ICA. And our further misfortune is, my lord, that if we read modification only in 2A, that is why Mr. Khambata was trying to restrict modification, perhaps restrict modification only to 2A. The problem is 2A is a ground, whereas the actual source of the power which we are trying to read is section 36(1). So you can't say setting aside includes modification for domestic, but setting aside does not include modification for ICA. There are difficulties there, my lord. There are difficulties, and my lord, to do a great right, one does a little wrong is also a little problem. So, my lord, this is my submission so far as the second proposition as to reading it. Now, my lord, I go back to the first proposition, because I'll finish in, my lord, 10 minutes. I go back to the first proposition. The first proposition is that it is a good idea that this court should step in and short circuit the process. After all, your lordships are there to do justice. So let's short circuit. Apart from the fact whether it is to be short circuited or whether that will itself involve another long circuit, one is not on that. But my lord, what is very interesting is two things. One is, what is that guideline and what it be legislated, what is the test to be formulated? Everybody on the other side is given a different test. So we don't know what the test is. And everybody will give a test aligned to, my lord, their particular facts of the case. But be that as it may, my lord, I just want to end by citing two important judgments. The rest I have, my lord, put in my note. I am not going to trouble your lordships. My lord, this exact issue of policy came up in a very famous case under the 1940 Act. Your lordships will recollect that under the 1940 Act, there was no express power that reasons had to be given. Lordship recollects under the night. And the matter went to the Law Commission. The Law Commission gave a particular recommendation. The learned solicitors read out the recommendation. The matter then went to a constitution bench. And the constitution bench affirmed what the Law Commission's recommendation said and kept its hands off. Even though, my lord, according to me, that's a much better case. That's a much better case that you ordinarily should have reasons in an award. I mean, after all, even on such a compelling argument, why did the court not interfere? And what were the policy reasons that weighed with the court saying, I'm not going to touch it now? Let the legislature look at it. Legislature did look at it, and we have the new act where reasons are required. So, my lord, I want to show 4 or 5 paragraphs from Justice Venkataramaya's judgment in Raipur Development. Just 3-4 paragraphs. You know, this is in volume 3, 1722. I put it in my note. I'll just read it. Your lordships will understand where I'm coming from.
Argued in this court, Mr. Banerjee, Mr. Nariman and Mr. Saurabh ji.
Yes, Mr. Nariman is correct. And I think the Solicitor General was not the.
Yeah, well.
2 Malone. Just 4 or 5 paragraphs, Malone. First, your lordships will look at paragraph 20 and 21. Justice Venkatamaya fully, Malone, analyzes the scope of challenge under the old act, and then he comes to paragraph 20, which your lordship will find at 1737.
Yes.
The Law Commission of India, however, had occasion to consider the question whether it should be made obligatory on the part of the arbitrator umpire to give reasons in support of the award in the course of its 76th report on Arbitration Act 1940, submitted in 78. Well, not the entire portion as to the reasoning is being set out, but I want to just, the entire portion is very instructive, but in the interest of time, your lordship will come to 4.45 or page 1738. There are it seems to us several considerations that are relevant in determining the question whether the arbitrator should be required by law to give reasons for the award. And my lord, various comments are made. I'm not reading that. Please come to 4.4.7.
Yes.
The previous experience, in fact, points out that these awards incorporating reasons which have generally been quashed, awards not giving reasons have survived the attack.
That was, I'll be very frank, when we joined practice, that was the reason given by most arbitrators.
My lord,
Why they don't give reasons, because the moment you give reasons, we are unable to challenge. But that had its own impact. But that had its own impact. That was the main ground which many of the most arbitration awards in the 70s, 80s, and before the 1996 award was passed.
One line.
One line.
now, my lord, the reason.
It was impossible for you to challenge.
Yes, the reason given. Lord, why
That
was
will-
that?
That was the wrong era.
The reason.
Party should not know the reason why
No,
they have lost.
I'm saying what were the policy reasons for coming to such a conclusion? My lord, the policy reasons was that the arbitrator, if honest, could be wrong. And two, that finality was something that was to
Mr.
be.
Mr. Banerjee, I think that was a mindset and rightly so, because there were doubts expressed about arbitration, efficacy of arbitration as a equitable and as fair a mode and as just a mode as court adjudication, therefore reason became compulsory.
My lord,
Unless the parties.
we come
arbitrate
back,
on-
my lord, to the point.
Let's not, that, there is no question.
Come back, my lord, to the point.
Don't leave that judgment.
Sorry?
They made an exception for.
Public
yeah,
sector.
public sector.
I know. I understand all. But my lord, the point is this.
Go ahead, Pala.
Two policy reasons why your lordship should not exercise a modification power are: one, party autonomy, and two, finality. The moment that exercise is carried out by the court, A, you go to a court, whereas you wanted to go to a tribunal. B, finality is thrown to the winds because the arbitral award would be the round of 16. Then you have a quarterfinal in 34, semi-final in 35, final in Supreme Court. And it would, my lord, that is, so two policy reasons.
Let us put it, this argument is equally applicable in the state when the legislature makes it, except to the extent, because if the legislature amends it, the argument will be the same. You'll have a round of quarterfinals, finals, and then.
I think, my lord, the reason it should be left
So
is
the
the
other
legislature will.
argument of yours, that it may have repercussions as far as the enforceability of the laws or awards made in India, will something which is to be considered, we put it to the others.
My lord, last one line, my lord. I just want to make a couple of points, and my lord, then I will conclude. My lord, there are three different, if I can understand, my lord, concentric spheres where we are concerned on challenge. One is that this is to answer Justice Vishwanathan's question. One of the narrowest sphere is the correct result. The correct result can only be within a narrow sphere. The slightly wider sphere is where there is an incorrect result as a result of misappreciation of evidence or wrongful application of the law. That is specifically provided in section 34. The largest sphere where the court will certainly step in is something beyond 1 and 2 and go to 3, whether it is patent illegality, whether it is a problem regarding the process. After having got to 3 and found that 3 is a problem, then to modify, your lordships are skipping 2 and coming to 1. So the interest example, my lord, which seems to resonate through the court. No? The interest example is very interesting. The party who has lost on liability. One party has won on liability. The party who has won on liability may have lost 4 other claims on liability. That cannot be open. The party who has lost on liability comes and says, please modulate the interest. The party who has won on liability can equally say, this means you don't trust the tribunal. The error that he committed on liability cannot be looked at in 34. It is a wrong view. I should have my day in court. And when it goes back and there is a set aside or annulment, all these issues are open, subject, as your lordship said, to res judicata, etc., limitation. My lord, there's a very nice judgment of the Court of Appeal of Sundaresh Menon. So, my lord, court is, moment it gets to that stage, it is, my lord, killing the snake without breaking the bamboo. It's that thin line where you don't look at the merits, but you correct the award. That's covered by 33. Or you find as a curable defect. That's covered by 34.4. So where is that other case, with due respect to all the various examples given by my learned friends? Where is that third case where you pull out some inherent power and say, I'll tweak it? Where is that case without disturbing the merits?
What is the position on res judicata? 4 claims, 3 claims.
Res judicata, I'll answer it simply. There is the judgment of Justice Menon, which we have put in on res judicata, where he explains what is the consequence of setting aside. So, for instance, consequence of setting aside is you go back to an arbitration. It may not go back to an arbitration, supposing the clause is void, supposing it is non-arbitrable. Then you go to suit. Subject to limitation, that is answered by 43. Subject to res judicata, if you already decided something, then that binds these. So all this has been looked at and dealt with. So, my lord,
So 3 claims attain finality. If the 4th one is set aside, if the award is set aside with specific finding.
On 4.
Then 4 alone will be open for.
Only open. And that's
Even we have held that KV George or something.
Yes, my lord. And this, the other the judgment I'm referring to is mentioned in my note is AKN versus ALC, also in the learned solicitor's note, 2015 Singapore Court of Appeal 63.
If res judicata applies, then what is the problem? There is no problem of injustice there.
My lord, this is the issue. This is the, my lord, desire to do justice and step into the arena from being the umpire to becoming the player. The umpire is always better than the player.
Mr. Vened, you're accepting it can be done, but you say that it should be legislative mandate because we have.
I am
You're
not accepting
it can be
it to be
done.
done. My view is it should be done.
You are
My view is,
accepting, not only you're accepting it should be done, you're also accepting it is done in some jurisdictions. But you say it should not be done by the court, but it should be done by the legislature.
it will cause, my lord, enormous difficulty.
The difficulty part is difficult to accept, except to the extent of international awards.
My lord,
Probably in
unfortunately,
case
we
the
don't have
objection
to act.
taken is, in case the objection taken is, because it's not an award, now it's a judgment of the court, and therefore the enforceability part will have to be dealt with differently.
My lord, the thinking, I go back, my lord, to the Red Fern portion. It is, the arbitration is not meant to be the first step in the process. That is how we are now thinking about it. My lord. Then, my lord, actually, I am with the solicitor. My lord, then if you want a full-fledged hearing and you want a full-fledged.
No, that's not the point. That argument doesn't, to be very frank, got too much ice for the simple reason that interference of the court will be still limited to the ground stated in 34.
My lord, if your lordship
And
limited to
if the
34 ground,
award musters, the award is not affected by any of the grounds in 34. There's no question of the court
what your
interfering.
lordship is saying, first clear the hoop of 34.1, find some patent illegality,
Correct.
then cure it then and there rather than sending it back. This is
That's
all. No, that is not the test which is being proposed.
No, that was the test. Let me put it.
By
No, that, let
any
me
of
put
the
it.
sides, my lord.
No, except for,
Then there's a question of will there be additional evidence?
no, there's
Will
additional
there be no
evidence which was
additional
already
evidence?
settled by this court. It can be recorded, but let us put it. We are not even going into that question. This
Then-
court has said.
No,
additional
because your
evidence-
lordships will be answering the question as to whether, assuming your lordships hold that power is there, then everybody agrees on the other side that it cannot be unchecked.
That, you leave that to us.
My lord, I think, my lord, I would end by saying this, my lord. I would mention, my lord, Justice Narasimha's comment, my lord, that we are overthinking this, my lord.
That's true.
We are
That's
really
not-
overthinking
Let
this.
me put it,
The
the way
section
arbitration,
says,
let us put
set
it the way-
aside,
Well,
please set aside, and let's stop there, my lord. We are not here, my lord, the court is not here, my lord, this is not a normal case. The court here is not to fix the problem. This is not the normal case where the court fixes the problem. It is not the court for the court to fix the problem. And that the entire purpose of arbitration is to step outside. If your lordships volunteer to fix the problem, your lordships will get more problems to fix. And that is the inevitable consequence. I would only say,
Okay,
yes,
understood.
deeply obliged.
Yes,
I'm sorry.
My lord, I beg to appear for IRCON, my lord, in IA 15336 of 2021, my lord. My lord, my submission, my lord, is twofold, my lord. I'll just at the outset say what my position is, and then I will give the theoretical basis of my position, my lord. My lord, in all probability, I will finish in less than 25 minutes, maybe 20 minutes, my lord. My lord, my position is, my submission for your lordship's consideration is that Section 34 of the Arbitration Act, as it currently stands, based on a correct interpretation of the section, court lacks the jurisdiction and power to modify or vary the award. That is my position, my lord. But it has the power to set aside a part of the award. So partial setting aside is permissible within the scope of Section 34, and I will read from the provisions to show how that is possible. But full modification is not possible. My lord, may I just hand over a note, my lord? It will help me just go through everything very quickly, my lord. My propositions are here, my lord. I have just two propositions, my lord. As part of these propositions, my lord, a subsidiary, as part of this stand, my lord, I will also take the position, my lord, that the power to vary the award is not a subset of the power to set aside the award, my lord. My lord, it is my most respectful submission for your lordship's consideration that there is an inherent flaw in that argument where one starts looking at the power of setting aside as a larger power and the power of variation as a smaller power, my lord. As a matter of arbitration jurisprudence, my lord, according to me, my lord, I may be wrong, I'm submitting for your lordship's consideration. My lord, according to arbitration jurisprudence, my lord, that is an incongruent and unbelievable argument, my lord. My lord, the first test, my lord, there are two propositions that I rely upon, both theoretical arguments, my lord. My lord, the questions before your lordships are based on the scope of Section 34 of the Arbitration Act as it stands today, my lord. It is my respectful submission that the scope can be tested based on application of two doctrines. And according to me, you apply those two doctrines and you get the full answer with respect to the scope, my lord. My lord, the first doctrine that I would request your lordships to consider and test the application of is the doctrine of merger, my lord. According to me, as per settled judicial precedent of this honorable court, the award does not merge with the Section 34 order. The Section 34 order does not merge with the award. That is the position in Kunaiya Ahmed and several other lines of cases. I will just show 4 paragraphs. They are very clear. In the absence of merger, my lord, the jurisdiction under Section 34 is only an annulment jurisdiction. My lord, it is like using a sledgehammer to get rid of the award in full terms. Or like saying, I will use a scissor and cut out the disease portions of the award. What remains still is an award, and what remains as the remainder of the award remains enforceable if your lordships exercise severance jurisdiction. But variation jurisdiction, my lord, is changing the nature of the award, and without a doctrine of merger supplementing the order under Section 34, what will become enforceable after this minor variation is full of difficulties, my lord. Let me give an example, my lord. The award says post-award interest of 16%. And your lordships do nothing but say, we don't interfere with the award. In section, not your lordships, but your lordships can do anything. But a court under Section 34 says, we don't interfere in the award. We are only making 16%, 12%, my lord. That is all. My lord, doctrine of merger does not apply based on the common law principles that your lordships have upheld in Kunaiya Ahmed. And there is no statutory scheme, as my learned friend pointed out, there is no statutory scheme that says that the order of 34 will merge with the award. My lord, in all other jurisdictions, I will give a table. Statutory provisions
Wherever there is a power of modification, statutory provision saying that the modification will merge with the award. So if common law doctrine as per Indian law does not apply for merger, and there is no statutory scheme to merge the order under 34 with the award, what remains enforceable, my lord, is a strange concept, my lord. The award remains enforceable as modified, but there is no merger. There is no merger. So, my lord, I find that very difficult. My lord, my first reason of saying that there is no merger, your lordship may just read 4 provisions of the act with me, my lord. Just 4 provisions of the act. My lord,
You are appearing in a case of international award or an Indian award?
my lord, I'm appearing as an intervener on behalf of IRCON, my lord, because we are facing similar questions in domestic awards before the
But tell me one thing. As far as merger is concerned, in a domestic award, there will be no difficulty. Merger, doctrine of merger with the Kuni Ahmed or others has always been a nebulous doctrine. It has its limitations, and because what merger does is the cause of action merges, the original cause of action merges, which led to the award. And any modification made, whether it's by way of reference or otherwise, we can always regulate it by that, because it's a doctrine of merger is not a statutory doctrine, it's a
common law doctrine.
it's a common law.
My lord,
doctrine. It has its limitations.
what I'm trying
Whenever we evolve the law, the doctrine will make its way, will comfort itself.
I take it, my lord, and I will answer that. What your lordships are perhaps saying that if your lordships read into section 34, the power to vary.
No, we're not even saying that. Doctrine of merger being a common law doctrine, it will be only applicable to the extent it does not come in conflict with the judgments of the court.
My lord, that is what I'm submitting, my lord, that the doctrine of merger as per Kunaiya Ahmed can never apply to an order under section 34. Tests are laid down, all tests are failed.
So that means you can go for fresh arbitration?
That is right, my lord. That is right.
No. Even after the award, you can go for fresh arbitration?
No, my lord. My lord, no, with respect, my lord.
Because the award is the merge cause of act, what res judicata, principle of res judicata is also based upon doctrine of merger.
Yes, my lord.
And the merger, once the award is passed, once it's not final and binding, res judicata doesn't apply.
Yes, my lord. My lord, may I answer this theoretically straight away, my lord? My lord, I will answer. My lord, I will answer this straight away, my lord. Straight away, my lord. There are 2 things, my lord. If your lordships say that the power to vary the award exists in under section 34.
If the setting aside exists, that power is subsumed.
Supposing, my lord, I'm assuming for a moment that your lordships are inclined to hold that, or your lordships are thinking of it. Obviously, my lord, your lordships will have to say then that there is merger. I accept that, my lord. Your lordships will have to
say. Obviously, the order which is enforceable will be the order of the court.
Yes, my lord. My lord, if your lordships say that, my lord, it would be 2 things, my lord. First, my lord, it would be contrary to the scheme of the act. I will read 4 provisions to show that, my lord. 2, my lord, it would be contrary to the principles in Kunaiya Ahmed. I would read 2 paragraphs to show that, my lord. And third, my lord, it would disregard that all international jurisdictions where a right to vary has been given have statutory scheme of merger, which our act does not have, my lord. 3 points I've made, my lord. They are part of my proposition.
Okay, let's see.
Your lordship may first see, my lord, section 5. I will not read anything, my lord. I just want to show that section 5 starts with my lord, notwithstanding anything contained in any other law for the time being in force, my lord. Settled principle, KSL, Arihant, and every other law, my lord. Your lordship has to read this to mean notwithstanding anything contained in CPC, notwithstanding anything contained in 151. My lord, that is what my submission is, my lord. The scope of interference by the court is limited to the manner in which it is prescribed. Your lordships may now have section 34, my lord. Section 34 provides recourse against an award. Recourse of a court against an arbitral award may be made only on an application for setting aside the award in accordance with the following. My lord, your lordship, this provision has been read time and again. Your lordships are aware, amongst other orders, 34(4) order can be passed remitting the award. After this, my lord, your lordship may see 35. 35 says, subject to this part, an arbitral award shall be binding on the parties and the parties claiming under them. So according to me, the only effect of section 34 can be, it will hit at the finality of the award. Whether the award will exist or it will not exist. The court can apply a principle of severability to say that I will sever a deceased part of the award, my lord. That is a separate doctrine, my lord. That does not even require merger. It will fall within the scope of section 34, a doctrine that will apply to any annulment jurisdiction, my lord. But my lord, what is very important, your lordship may see section 37, 1(3), section 31, C, my lord. What is it that is possible to appeal
after 34 court has exercised its jurisdiction. My lord, it says, an appeal shall lie from the following orders and from no other orders to the court authorized by law to hear appeals from original decrees of the court passing the order. An order of setting aside or refusing to set aside an arbitral award under 34. Clear indication, my lord, that all that the court can do, set aside or refuse to set aside. If the court sets aside, my lord, it will be an appealable order. If court refuses to set aside, it will be an appealable order. If court decides to remit under 34(4), it will not be an appealable order. If court decides to set aside, finality under 35 is gone because the order is effaced from the face of this earth, at least within the territorial jurisdiction of the court.
The argument misses the point. If the award is modified under 34(4), it will be again amenable to jurisdiction under 34.
Yes, my lord. Supposing, my lord.
So therefore 37 will not apply.
My lord, supposing your lordship.
See the first stage examination 34 and not on 37.
My lord, I ask myself, my lord, unless I've not understood the question.
That's the answer.
My lord, unless I've not understood, my lord, what fell from my lordships, my lord.
What happens, suppose an order is passed under 34(4), the arbitrator then passes an order in terms of that. That order will be an award.
Yes,
which should be enabled to 34.
Absolutely, absolutely. What I'm
37 doesn't apply in that.
Of course, what I'm saying, my lord, is that an order of variation of interest from 16% to 12% does not fall within the order of setting aside or refusing to set aside.
So that means if the court does it, you're powerless.
That is what the impact would be, my lord. If it is read that the power of variation exists, that is why I'm saying that the power of variation cannot be implied with utmost respect, my lord. What is the effect of saying that there is a power of variation in section 34? Effect number 1, my lord, your lordships are saying under 34, we believe that there is power of...
If it is covered by 37, if it's covered by setting aside, then it will be covered by 37.
My lord, that is what
if it is not covered by 37, if it is not covered by setting aside, then the appeal will not lie before the division bench, it will lie before the Supreme Court.
Yes, my lord. So two things will happen. Two things, my lord. My lord, two things will happen. Your lordship will have to read the power of variation within the power to set aside or refusing to set aside. There is no power to uphold, my lord. This does not say that the court has a power to uphold. It will have to be read into the power of setting aside or refusing to set aside.
Right to that.
My lord, therefore, my lord, three things will have to be done. The power of variation will have to be read not only within power to set aside and refusing to set aside, it will have to be read within the expression set aside in section 34. And my lord, under section 35, the award will also have to be read as an award as modified by the court under section 34. 3, my lord, what is being asked, my lord, what your lordships are being asked to do, my lord, is to read 3 jurisprudential concepts into powers under section 34, into powers under section 37, and into powers under section 35, my lord. My lord, if, first of all, my lord, I think, my lord, that is too much of a stretch that the other side is asking your lordships to carry out, my lord. But if it was jurisprudentially permissible, my lord, your lordship may see, if I am able to show based on Kunaiya Ahmed to your lordships that the principle of merger does not apply, then whether your lordships should read a power of variation into 34, contrary to the settled principles of merger under Indian law, is also a question that your lordships will have to answer, my lord. Your lordship may see Kunaiya Ahmed, what your lordships have held, my lord. It is a part of my compilation, my lord. Compilation volume 3, my lord. If your lordship would please have paragraph 18, my lord, starts at page 1895. My lord, I'll just be very brief on these cases, my lord.
So, Bajnanda, 1 minute before you go there. What happens if instead of resorting to 34(4), a party says, cut the matter short, I am not pressing that claim in the 34 court. He says, I don't want to even take that chance, I'm running against time. 34(4) may happen, may not happen. I'm interested in sustaining the award. I'm not pressing that claim to the court.
My lord, that is what I'm saying. My lord, your lordship.
What happens?
Yes, my lord. Your lordship's question presupposes that 34(4) is a view that the court has taken with respect to a part of the award. 3 claims.
34(4). Before going into 34(4), the party which has got the award says, much haggling is going on this issue. I'm not pressing that claim. This claim I'm not pressing. According to you, the court can't even record, not pressed, and sever it.
My lord, it can. My lord, my position is very clear that when your lordships are going to sever an award, the severance jurisdiction is a...
Let me put it slightly different. Suppose the claim awarded is 1 lakh, The party says, okay, I'll accept 50,000.
My lord, your lordship would be recording a settlement. It would,
Then enforcement,
my lord, conceptually, my lord, it is impermissible under the act, my lord. Conceptually, it is impermissible under the act. My lord, I say that, my lord, that is a difficulty. My lord, I'll just answer that. My lord, what I am submitting is slightly different, my lord. Your lordships will be faced with three situations, my lord. Your lordships, let us talk only of the interest, my lord. Your lordships have a situation before you where your lordships feel that 16% or 26% interest post-award is extortionate. It satisfies the test of setting aside. My lord, what your lordships can do without doubt is set aside the award only with respect to post-award interest. It does not need to merge with the award. Your lordships have used a scissor and cut the last 4 pages of the award.
and what happens to the party? You'll have to go and re-engineer that portion.
That is the scheme of the act, my lord. With respect to post-award interest, the matter has been relegated as if the party is never arbitrated, and it is open. Your lordship's findings will be res judicata as findings of your lordships sitting independently as a court. But there would not be a merger of your lordship's order under section 30, the court's order under section 34 with the order, with the award, my lord. My lord, your lordship may.
Consent, how do they record consent? In what form? Will there be a consent decree?
My lord, as I said, my lord, it is
award enforceable as per CPC under 36(1). The enforcement is in accordance with the provisions of CPC.
So that is how, so then it will be enforced. The judgment will now be the form of the decree and that will be enforced. So whether it is consent, whether it is unilateral giving up, whether it is court fine tuning.
Enforcement will be as per CPC.
My lord,
But only enforcement will be.
So if you just put this in extremes, in binaries, one way or the other, then all these problems you see arise. After all, what is this arbitration? You have to keep 28 of the Contract Act in mind. A limited exception was made not to go to the courts of the country because it's a judicial procedure agreed by the parties. Now you come back and say that even this can't be done because the award is what can be enforced, and if the court even on a giving up modifies, it loses the sanctity. Internationally, it will not be treated as award.
My lord, I may come back to your lordships on the issue of settlement. Your lordship may give me a few minutes. Let me reflect on it, my lord. But what I'm submitting is slightly different. Your lordship may consider this, my lord. First of all, my lord, I have no difficulty with the concept of severance because I believe that severance is a subset of annulment juris.
That you understood. So that's over. Yes, now the only question is, one, variation, even of typographical errors, calculation errors, you say is not permissible. Two, you say patent illegality or conflict with fundamental principles of law, again, not permissible.
My lord, that is my submission, my lord. The very purpose of section 5 is to limit the interference of courts in arbitration proceedings. My lord, may I put it slightly differently? My lord, perhaps I'm just hoping, perhaps this will.
Doubts on doctrine of merger, suppose. Suppose it is held that the award holds that the claims are within limitation. The court finds it's patently barred by limitation and therefore sets aside the award. Correct?
Yes, my lord.
Will doctrine of merger not apply?
No, my lord, the award.
My lord, can file a civil.
Yes, but I'll answer that, my lord. I'll answer that.
Where is res judicata? Because
res judicata, my lord, I'll just answer, my lord. The determination made by the court as a dispute between the parties in section 34 jurisdiction will stand alone and independent and hold res judicata. It will be a determination made by court in a dispute brought before the court by two parties, and there will be principle of res judicata with respect to that determination. Issue is not also.
Res judicata is based upon doctrine of merger.
My lord,
that the original cause of action gets subsumed. It's a part and parcel of the judicial order. Therefore, you can't rely upon the original.
May I answer that, my lord? Your lordships are talking about a situation, your lordships have put to me a situation where your lordships have held that the award is with respect to a claim that is barred by limitation.
That's an example.
Yes, your lordship may see that example, my lord. The effect of that set aside order will be two things, my lord. That the award has ceased to be in existence. As a result of the award being ceasing to be in existence, under section 43(4), it might be open for the party to re-agitate, but Your lordship's determination in the 34 court will be res judicata and issue estoppel between the parties. It will not be merger. It will be an independent doctrine of res judicata and issue estoppel arising from a court proceeding that has taken place because the award is effaced, my lord. It has ceased to exist.
In the example of the Honorable Chief Justice.
Yes, my lord.
If after limitation has been held as a ground to set aside the award.
Yes, my lord.
A section 11 is filed, High Court or here, depending on the nature of the arbitration. That stage you can't go into res judicata?
Of course, my lord. If the award is not a live, if the claim is not a live claim, I will show a judgment and say, my lord, this is the only claim.
Say, let us see the pleadings and the order, etc.
My lord,
So then,
my lord, the difficult, but first two things, my lord. Fact-dependent cases should not impact the underlying jurisprudence of arbitration, my lord.
No, you are saying on the merger, see, it all took off on the doctrine of merger. So, that is where it was pointed out. What happens in these kind of matters?
My lord, three facets. My lord, before I test, my lord, before I take your lordships to Kanhaiya Ahmed, that takes 2 minutes, my lord. My lord, the scheme of the act is your lordship has a jurisdiction to set aside. The court has a jurisdiction to set aside or refuse to set aside an award. After setting aside or refusing to set aside an award, impact only on finality. If your lordship says set aside the award, finality goes away. And under section 43, my lord, section 43(4), parties are free to arbitrate. My caveat is that it does not take away the determination of of the court with respect to res judicata and issue estoppel. Those will bind in subsequent proceedings. Now your lordship may say Kanhaiya Ahmed, please, my lord. Your lordship may say Kanhaiya Ahmed. It is in volume 3, page 1895. 3 paragraphs your lordship may see. So I'm so sorry, my lord. My lord, it is page 1918, my lord. I'm so sorry. Volume 3, page 1918. Well-known judgment, yes. 3 judges of this court, my lord. 1918, volume 3. My lord, in my note, para 7, my lord.
Yes.
My lord, in my note, para 7, the paras that I'm reading are, my lord, para 7 to 12 and then 42 to 44. My lord, your lordship may please have paragraph 7, my lord. Your lordship has it. My lords have it, my lord. My lord, as far as my submission is concerned, with respect to no power of variation, it is pivoted on no merger, my lord. That is why I'm saying that if your lordships conclude that there is merger with respect to no power of variation, this is my only argument, my lord. Your lordship may now see, my lord. My lord Justice, my lord the Chief Justice has it.
Yes, please.
My lord may see paragraph 7, my lord. The doctrine of merger is neither a doctrine of constitutional law nor a doctrine statutorily recognized. It is a common law doctrine founded in principles of propriety in hierarchy of justice delivery system. On more occasions than one, this court has had an opportunity of dealing with the doctrine of merger. It would be advisable to trace and set out the judicial opinion of this court as it has progressed through times. And then the case is quoted, my lord, CIT versus Amritlal. There can be no doubt that if an appeal is provided against an order passed by the tribunal, the decision of the appellate authority is the operative decision in law. If the appellate authority modifies or reverses the decision of the tribunal, it is obvious. My lord, reversal on merits is very different from annulment, where all that the court is saying, the award ceases to exist, you go back and arbitrate. Here it is saying modifies or reverses the decision of the tribunal. It is obvious that it is the appellate decision that is effective and can be enforced. In law, the position would be just the same, even if the appellate decision merely confirms the decision of the tribunal. As a result, well, there is no confirmation under the Act also. As a result of the confirmation or affirmance of the decision of the tribunal by the appellate authority, the original decision merges in the appellate decision, and it is the appellate decision alone which subsists and is operative and capable of enforcement. Lordship may come to placitum F onwards, my lord, same page, my lord. While doing so, this court analyzed several provisions of the Income Tax Act so as to determine the nature and scope of the relevant appellate and revisional powers, and held, my lord, this is important, if the subject matter of the two proceedings is not identical, there can be no merger. In state of Madras versus Madurai Mills, this court held that the doctrine of merger is not a doctrine of rigid and universal application, and it cannot be said that whenever there are two orders, one of the inferior authority and the other of the superior authority, passed in appeal or revision, there is fusion or merger of the two orders, irrespective of the subject matter of the appellate or revisional jurisdiction, revisional order, and the scope of appeal or revision contemplated by the particular statute. The application or doctrine of the doctrine depends on the nature of the appellate or revisional jurisdiction, or orders in each case, and the scope statute.
We have understood this because paragraph 12 makes it clear. Look, as I said, initially, it's not a statutory doctrine, neither a constitutional doctrine, it's a common law doctrine. It depends upon facts and circumstances of the case. If the section 34 is to be, we'd not like to bring it. The income tax matters, why it becomes important is because there are multiple stages.
Yes, Paula.
There are multiple stages, and difficulty which arises sometimes is a portion of the appeal is decided, portion is remanded. Therefore, that doctrine of merger over there becomes very important.
My lord, may I just read
Because 263 powers are there, 148 powers are there, where particular portions are taken
My
into
lord, may I
account.
just read a few lines from 42 and 44, my lord. Just a few lines, my lord. And then I will move to my next point, my lord. My lord,
Your time is getting over now.
my lord, may just bear with me for 5 minutes, my lord. My lord, to merge means to sink or disappear in paragraph 42, my lord. To merge means to sink or disappear in something else or to become absorbed or extinguished. To be combined or swallowed up. Merger in law is defined as the absorption of a thing of lesser importance by a greater, whereby the lesser ceases to exist, but the greater is not increased, and absorption or swallowing up so as to involve a loss of identity. We may look at the issue from another angle. The Supreme Court cannot and does not reverse or modify a decree or order appealed against while deciding a petition for special leave. The court held that a mere permission leave to appeal, it does not result in merger, because we are not exercising identical jurisdiction as of the court.
Yes, therefore, there was a further reference, another decision.
If your lordships were
Even can be filed before the High Court. Correct. Doctrine of merger doesn't apply. Correct.
SLP on several grounds, it does not mean that we have affirmed that.
My lord, if your lordships were to hold that section 34 includes within its scope the power to vary, then your lordships will have to hold that under 35, award includes award as varied by the court.
Correct.
Under 37, your lordships will have to hold that the variation.
You're right, to that extent, you're right.
One more thing, my lord. Your lordships will then be doing that in the absence of similar provisions as exist in other international statutes.
Something different. We have to look at our statute. We can, keeping in view our circumstances, look, keeping in view our circumstances, if we find there is a scope for that, we'll see.
All I want.
We may be guided by the international jurisdiction, but they're not binding on us.
My lord, all I wanted to say is I've given a table. All other jurisdictions where power of appeal modification is given. My lord,
I have been saying,
When to apply, when not to apply is also with us.
yes,
my lord,
I have been saying this not since long. Why being slaves of the forest?
No, there's no question. Look, please. Mainly because we apply, we are not slaves, certainly not. We apply with our consequences in mind.
They are persuasive,
They are persuasive.
but it should
No,
not.
not binding.
It is not them.
Light from all sources.
Sometimes,
Light from all sources.
yes, but
You have also relied in your arguments on other jurisdictions.
sometimes it is treated to be more binding than.
Than Indian rules.
my lord, I'm moving to my next point, but your lordship may just test my argument on one conceptual basis, my lord. My lord, there is one situation in which I submit that the decision of the 34 court would be res judicata on its own terms without merger because the award has ceased. And the other argument, my lord, that comes to me is no, it results in merger and then it becomes res judicata. My lord, if it results in merger and then the decision becomes res judicata, then nothing remains for the purpose of 43(4) to adjudicate.
No, that's a statutory rule.
My lord,
That's a common law doctrine, that's a statutory.
my lord, if the
rule.
cause of action, my lord, I say that if the cause of action has merged in the order under 34 and that has become res judicata, then 43(4) becomes irrelevant. My lord.
It depends upon, it all depends upon the nature of order passed under 34.
My lord, I've now come to my second proposition, which will take 3 minutes, my lord. 3 to 5 minutes, my lord. My lord, your lordship may come to please come to paragraph 15, my lord. I wanted to say, my submission is this, my lord. even if I say that annulment jurisdiction is very different from appellate jurisdiction, variation jurisdiction, my submission is they are chalk and cheese. They cannot be mixed, my lord. There cannot be merger. Even in that case, my lord, the principle of doctrine of severability can apply to say that I will not annul the whole award, but I will only annul separable parts of the award. And that, my lord, is a use of a smaller power subsumed within a larger power. There, your lordship's principle that was put to me will apply. That is dealt with in my second proclamation. My lord, I wanted to submit this, my lord. Your lordship will see in paragraph 15, I have referred to a case called R.S. Jivani, my lord. This was a full bench judgment of the Bombay High Court, my lord. 3 judges who eventually became judges of this honorable court, my lord, full bench decision of their court, which held there is no power of variation, there is no power of modification, but power of severance exists. And they applied doctrine of severability to set aside, answer a question that separable parts of the award can be set aside. Your lordship may conceive 3 situations that I'm putting before your lordships, my lord. My lord, an award will be an award where there is liability and quantum decided. There is a breach of contract and I give you 100 rupees as damages. The principle of severance, my lord, severability can say, I will uphold the award on liability, that you have breached the contract. But 100 rupees is not the right amount of damages. I'm setting it aside, and that can go back to arbitration. We see it every day, my lord, in international arbitration, in domestic arbitration, that awards are separated on liability and quantum. Liability is upheld, quantum is set aside, and quantum goes back to arbitration, my lord. That is one situation. The other situation will be, my lord, where 3, 4, 5 claims are decided together, but one claim stands independently and can be set aside. For example, my lord, a person makes a claim for loss of profits for a premature termination of a contract, says my contract was terminated 12 months earlier. During that period, he also makes a claim for escalation. And the arbitrator awards loss of profits as well as escalation. And your lordship say escalation is covered. If I've given you loss of profits, it's covered for those 12 months. My lord, in that case, the claim with respect to escalation can be separated and the award for loss of profits can be upheld, my lord. That will be the second situation, my lord, in which there will be a severance of the award, my lord. And the third, my lord, classic case of interest. Your lordships find that interest is extortionate. It is within your powers, my lord. I'm so sorry, my lord, within the powers of the Section 34 Code to say, I set aside the award on interest. Then your lordships can even exercise, if one of you are willing to agree, I will send you back to the arbitrator and he can cure this, in my view, that this is extortionate. But your lordship cannot change the rate of interest, my lord. That is my position. That variation cannot take place. What I wanted to submit, my lord, is that the full bench decision in R.S. Jivani was relied upon in a division bench judgment of Puri Construction of Delhi High Court in division bench, which is referred to in paragraph 16, my lord. In Puri Construction, the award of liability was upheld, that correct, this party was in breach of contract, but the entire award on quantum was set aside, saying that we are setting aside the award on quantum, thereafter we are leaving you free to decide and assert your rights in accordance with law. Both, while doing so, my lord, Puri Construction relied upon R.S. Jivani's case, my lord. What I'm submitting, my lord, is that this Puri Construction, where it relies upon R.S. Jivani, was affirmed in Hakim in paragraph, my lord, 30 and 31 by your lordships, my lord. So therefore, my lord, my submission is in paragraph 30 and 31, Hakim has noticed Puri Construction, and your lordships in Hakim have noticed R.S. Jivani, and your lordships have impliedly affirmed the principle of severability of an award. But I repeat, my lord, severance is very, very different. Severance is an annulment jurisdiction. It is very different from an appellate jurisdiction, my lord. I again say, my lord, that it may be, according to me, it may be a bit of a stretch to say that a Section 34 order, when the word appeal vary is not used, is intended to merge with the order because it is only an annulment jurisdiction.
Okay.
That's
Thank you, sir.
much grateful.
You are there. Okay. Just 1 minute. Take it back.
Just 2, 3 small points, my lords. Everything else is covered by the arguments. My lords, the statement of objects and reasons was read by Mr. Kripal this morning, but paragraph 3, my lords, just paragraph 3 I want to put.
We have read it. We have read it.
Yes. My lords, it says that the Institute of Model Law and Rules are intended to deal with international commercial arbitration and conciliation. They could, with appropriate modifications, serve as a model for legislation on domestic arbitration and conciliation. So, my lords, legislature had the power to make some modifications. And 4, Roman 1 says, the main objectives of the bill are as under, to comprehensively cover international commercial arbitration and conciliation as also domestic arbitration and conciliation. So now the institutional model law was adopted as it is, but subsequently there have been two amendments, 2015 and 2019. So whenever the legislature felt the need to bring in some amendments, that is, and my lord, second point is that under 34(4), my lords, my submission is that the awards which are patently illegal or which are against the basic framework of the Indian law or something, they cannot be sent back.
Also clarify.
Right. And therefore, my lords, the power of modification would not come. Otherwise, my lords, if we go into the power of modification, then my lords, the court has to necessarily go into the merits of the case, reappreciate the evidence. And in that case, my lords, just one example I'll give. The arbitrator awards compensation for 12 months delay. The court may, in a given case, say, no, it's not 12, it is 10. They'll pro rata reduce it. The court may say it is not 12, it is 16. They may pro rata increase it. So, whereas modification would then impinge upon explanation 2 and 34(2)(a). So, therefore, my lords, modification is fraught with all dangers and therefore it should not be allowed. I have to submit only this one. The rest is all covered by. I'm highly obliged to my lords.
We just take 2 minutes, my lord. Just few minutes. I want to show one judgment, Lord, which is there in the McDermott case, which says with the question that came from Lordship as to what happens in a situation where the award is set aside. Lord, para 52 of McDermott says that the parties have the right. Lord, in my submission, the real problem that has to be addressed is how the second part has to be solved. How the part as after setting aside has to be dealt with. If we start finding solution in modification and varying, the solution will start becoming a problem. Lord, there are 4 situations. Yes, my lord.
Already argued.
Lord, therefore, Lordship may only consider one thing. Is the power to set aside, please see A and B. 34(2) has 2 parts, A and B. A, nothing can be modified. It can only be set aside in A. That is, when the arbitrator is incompetent, when the matter is beyond reference, there's nothing for Lordships to modify, or the 34 court to modify. In B, also, there is nothing to modify. It at best can only be related to C. Now, Lord, if defect can be cured by modifying or varying, that means that defect, actually the defect are such that they cannot be cured. Now, the only problem that remains is with respect to interest or at best costs. Lord, 3 things Lordship may consider because interest and cost is something that always bothers everyone. Lord, first point, in interest, the date when the interest has to start, the quantum on which interest has to start, the rate at which interest has to start. These 3 things, my lord, many a times, the 34 court may not have the data, the full details available with them to be able to grant or reduce or reject the interest. Lord, we have large number of cases where interests are refused. We file a section 34 challenging the refusal of interest. What is the order that Lordship would consider, or 34 court would pass? Okay, the rejection is incorrect, but you go back to the arbitrator who can reconsider your interest. Or would the 34 court now start looking at all the materials on record, appreciating evidence, because now we are even filing the materials to justify our interest. Lord,
okay, that's all. Yes, anybody else?
Just 2 minutes I'll take with respect to one.
Written notes now.
Well, as I'll give a written
note. The law commission perspective.
Only one
That's
aspect.
already been pointed.
No, my lords, the entire thing, the 246 and 246 supplementary is something that has not been pointed out.
Give it, just give it.
Only one aspect, my lords. One argument was taken by the other side.
Yes.
Yes.
Yeah, what
Lords,
is
this is a short part of it, my lords. 3 things happened before the 2015 amendment, my lords. There was a 246 report of the Law Commission, which laid down upon the narrowing of the Arbitration Act, the Western Gecko judgment and the 246 supplementary reports, my lords. What came out from the 246 supplementary report, my lords, in para 11 was the subsequent amendments that came in 34(2) and 34(2)(a). And why was that done, my lords? Was so that the over-expanse that was then given in Western Gecko would otherwise not happen. Therefore, by 34(2)(a), my lords, what further came in was a further limitation into the appreciation under 34(2)(a). Now, my lords, after this happened and the understanding of minimal judicial intervention also comes from a Law Commission reports, as seen right from the 176 Law Commission reports, my lords. In fact, in the 222nd Law Commission reports, my lords, the answer to minimal judicial intervention was then seen as institutionalized of arbitration for greater quality control and checks and balances in the final awarding of the award or final publishing of the award, my lords. That is why the legislature has then worked upon until 2019 with the B.N. Sri Krishna committee, with the notification of 12th October 23, where institutional arbitration then came in. So this was seen as an alternate, my lords, to the extent of judicial intervention, which could then come up. The third aspect, my lords, is that as it is, and this reflected in the 2015 amendment, my lords, where we had a chance to undo what had happened in 34, but we further reiterated and ratified our commitments, which are rooted in international documents and our international obligations. Thirdly, my lords, the principle of minimum judicial intervention and no review on merits is also today a generally accepted principle of international law, which has been accepted across jurisdictions, for which I've given the relevant evidence and citations in my documents and my source, my lords. Third and not the least, my lords, it is in light of this minimal judicial intervention, as seen in the 246 report, as seen in the 2015 amendment, there is a perspective that comes to 34.4. And that is, my lords, because of the narrow understanding of 34.2a as provided by the Law Commission report, 34.4 therefore kicks in, where an opportunity may be given because modification was not provided for either by the Law Commission or accepted in the 2015 amendment, my lords. I'm grateful for my submissions. Thank you.
Yes, Manoj. Just one point I wanted to make, Manoj. One argument which was taken by the other side was to make the provisions of CPC applicable so that 34 court may have a power, Manoj, to modify the award. And Manoj referred to the judgment of ITI Siemens, which was referred to by Mr. That has been, Manoj, referred to a larger bench and applied with only one judgment, Manoj, which is with respect to Amazon, wherein, Manoj, your lordships have held that although there is section 17 provided for the purpose of enforcement, you can go to CPC, provisions of CPC. This court says that that is only a legal fiction. That would not give a right, Manoj, for the courts to apply CPC, because Manoj, in Manoj Amazon, section 17 order was taken up in an appeal under CPC, under order 43, for the reason that the argument was that under section 17, the enforcement has to be done under CPC, therefore the appeal would lie under order 43. Your lordship, Manoj, clearly states that that's a legal fiction and CPC would not be applicable. So, Manoj, even to apply ITI, Manoj, which is under Manoj's reference to a larger bench, would not be, Manoj, with great respect, Manoj, applicable, since if CPC should not apply, Manoj, with respect to the provisions of section 34. That would, the rest, everything has been argued by everyone.
Yes, Mr. Schwartz.
Please. But I'll be as short as possible. But I'll start with what my learned friend left application of CPC, because Mr. Datar's argument emanated from the fact that section 9, he read the provision which defines the court under section 2 of the Arbitration Act to mean the court of original jurisdiction. Then he referred to section 9 of the Civil Procedure Code. Then he referred to section 151 and said that if it's a court of original jurisdiction, be it High Court or the District Court, then 151 would apply. Lord, section 9 itself provides that the applicability of CPC can be excluded by implication or by express terms. Lord, here section 5 of the Act, Arbitration and Conciliation Act, expressly or impliedly, whichever way we look at it, do not exclude CPC. Lord, your lordships may kindly have a look at section 5. It's read and reread again, yes, but Lord, for this purpose, yes, that whatever steps are to be taken with respect to the arbitration under this Act shall be only as provided under this Act, except where CPC is made specifically applicable.
Which portion you are reading?
5, section 5. Bro, how CPC is excluded? Lord, extent of judicial intervention, notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Meaning thereby CPC is excluded except whichever sections provide for application of CPC, and that section, my lord, is section 35, my lord, kindly, section 36, for example. 36, it applies CPC. 36 is enforcement proceedings.
Section 5 doesn't specifically refer to CPC, but as far as section procedure is concerned, there is arbitral procedure that specifically excludes both CPC and the evidence that.
Lord, I may, my lord, only point out, not, my lord, just arbitral procedure. My lord, it says under this part, my lord, this part would mean including section 34, 36, 37.
Solicitor, the problem with that argument is
Yes,
151 is not a conferral of inherent power.
yes.
151 is a recognition of a pre-existing inherent power in a
Power,
court.
provided the provisions, my lord, empowering the district court or the high court to exercise power under 34 permits exercise of CPC.
So just see 151, how it is couched. It is saving,
Lord, I wish to show.
No, Mr. Let's suppose by chance,
Pardon?
let's say by chance, the objections are dismissed on the ground of non-prosecution or because nobody is present. Will it not be, you can't revive it?
No, that would be the inherent powers of the tribunal,
Yes.
not 151.
So 151 is also recognition of the inherent powers.
one more example following the chief justice. Suppose in a 34 petition,
Yes, my lord.
objection to jurisdiction is taken up. Every court has the inherent power to decide its own jurisdiction. It's only vested in the court. That will have been
Tribunal also, but
no, tribunal will be confined. See,
16, my lord.
For that matter, amendment.
What we want clarity is, we should not unwittingly think of the court hearing a 34 as if it is a tribunal which is a creature of the statute. The court is given additional power under 34 to exercise jurisdiction, and 151 is a saving of the inherent power.
Lord, if I take your lordships to few of the provisions, your lordships would be satisfied. That
So this argument may have its own difficulty to accept it, because even order 6 rule 17 will not apply, interrogatories will not apply.
Order
The power of
39
power-
2A will not apply.
This court judgment says additional evidence can be read, coupled with, if you turn to 19 now, 19 in specific terms say, it will not be
It will
bound
not
by.
apply.
Here, it's not specific. So
Yes.
there will be, let's not do that, it may have its own consequences.
Yes, my lord, it's better not to travel that path, my lord.
That
151
should not
path,
travel that far.
my lord, 151 path to trace the power of modification would be flawed with several things which we are unable to conceive at this juncture. But right now, the only limited question is,
So
where-
151 power is only was invoked by them only to correct arithmetical, clerical mistakes, etc. Which is power is something which is there. Recall power is not there, but we have read it into it.
Lord, another thing, my lord. Please see, my lord. There is a complete code, my lord. How the scheme of the code runs, my lord. Please have a look at, my lord, for section 9. Please come to section 9. Yes, well, please come to section 9, my lords. Well, what would happen, my lord, if your lordships were to, my lord, expand the scope of applicability of CPC? My lord, CPC permits a mandatory injunction being granted. Section 9 permits, my lord, interim measures of protection, one of which is an injunction, not mandatory injunction. It would come, my lord, section 11(6)(a). My lord, if we expand the scope from what is statutorily provided in letter by looking at the spirit of the provision, 11(6)(a). My lord, 11(6)(a), your lordships are aware, my lord, the Honorable Chief Justice or his lordships designate earlier used to go into the question of arbitrability also. Now, my lord, the legislature has curtailed that power to only see whether there exists an arbitration clause. If, my lord, inherent powers or 151 powers or any power beyond what is stipulated, my lord, is read dehors section 5 of the Act or the letter and spirit of section 5 of the Act, my lord, we would be, my lord, doing violence to the language.
Let's put it very clearly.
Yes.
If we are accepting section 5 puts a limit to the court powers. The question is, what is the ambit of section 5? What they've argued is, it will not violate, section 5 will not be violated because it accepts, if we accept the argument that setting aside includes even right to modify, subject to limitations. It also includes the power to rectify, correct arithmetical errors and clerical mistakes and calculation mistakes, which are there not specifically provided for in 33, but not in 34, but in terms of the inherent powers of the court, which are not taken away even as a court dealing with a limited jurisdiction in terms of 34.
Correct. Now, please come to Malord 13, challenge procedure. I want to show two things, Malord. A, it's a self-contained code and every step has its own consequences and a mechanism to challenge. Malord, Section 16, my learned friend pointed out, Malord, that example, that somebody challenged Section 16 order, interim order, by way of filing an appeal under Order 43, Rule 1R, and your lordship said that no, CPC would not apply. Now, please come to Section 13, my lord. What would happen if I were to challenge, my lord, this order? Because it is otherwise not challengeable except at the stage of 34. Please come to, my lord, Section 13.
There is no arbitration.
Arbitration, yes, Section 13.
If I'm not mistaken, earlier, FAOs will be able to file against interim orders passed by the arbitration.
Well, under 48, not under this act.
No, even under the 96 Act.
My knowledge.
Yes, at Delhi High Court, we were entertaining pursuant to a judgment of the Supreme Court. I don't know whether the judgment still holds court or not.
Lord, not to my knowledge, my lord,
I remember coming from some case. But now 227s are being filed.
Lord, 227 also, my lord, the Constitution bench says not being.
I know.
But division bench, my lord, I'm not going into it.
You have pointed out that I was.
That division bench said that it's a constitutional power and therefore cannot be taken away by statute. But it is to be
right. Prior to 2015 amendment of the Commission and introduction of the Commercial Courts Act, the dynamics changed.
Commercial Courts Act.
Yes.
By Section 30.
FAOs were being entertained.
There is specific bar was brought.
I think, my lord, if your lordship sees 4 sections.
No, Vishal Mehta, just check up on that. I've dealt with in Delhi High Court.
No, your lordships must have dealt with it. I'm not, my lord,
I
I'm
have
only
raised
on
that
a point.
objection because we are always very fond of raising objections.
I'm only on a point that it is a comprehensive and tailored code, which is a self-contained code. Wherever legislature wanted a challenge mechanism, it is provided with the stage at which the challenge will be made. Therefore, I was showing Section 13. Subject to subsection 4, the parties are free to agree on procedure for challenging an arbitrator. Failing any agreement, your lordships can skip 3. Unless the arbitrator challenged under subsection 2 withdraws from his office or other party agrees to challenge, the arbitral tribunal shall decide on the challenge. But we say that the arbitrator is biased. The arbitrator will have to decide on the challenge. Arbitrator decides that no, I am not biased. Lord, what is the remedy? Section 5. Kindly have a look at Section 5. I have no remedy but to proceed with the arbitrator and raise that ground at the stage of 34, where an arbitral award is made under subsection 4. The party challenging the arbitrator may make an application for setting aside such an arbitral award in accordance with Section 34. I am saying it is a self-contained, well-tailored, comprehensive code providing for the challenges inbuilt and the stage of challenge. My lord, please have a look at Section 16 now. Section 16 has, my lord, an internal appeal mechanism. I don't have to wait for the arbitral award to pass. My lord, 16 is competence of arbitral tribunal to rule on its own jurisdiction. Competence principle. My lord, if suppose I challenge that this tribunal has no jurisdiction and I fail in that challenge, then I, unlike subsection 5 of Section 13, I need not wait till the award is passed. I can straightway go under Section 37. Kindly have a look at, my lord, Section 37. A direct appeal lies before the award is passed.
In the event of the plea being accepted.
Yes, yes. Only if it is accepted. Only if it is accepted. So, meaning thereby, my lord, there is a conscious framework of the legislature, my lord, providing for each stage the stage at which a challenge would lie, and the forum before whom the challenge would lie. Lord, therefore, reading something into it, Lord, to find out the solution of a problem which generally Lord, admittedly exists. I am not running away from the fact that at times it is in the interest of justice that the power be conferred to modify the order. Lord, that is a problem, but that is a conscious legislative choice of not conferring that power because it had the power under 1940 Act. It was flashed, flagged. Thereafter, my lord, also when 1996 Act came, my lord, it is not conferred. The remedy can still lie, my lord, before the tribunal. My lord, on the last occasion, day before yesterday, my lord, the Honorable Chief Justice, my lord, was pleased to say whether there is any jurisdiction where this issue is raised, that power of modification not being conferred specifically, what will be the position? My lord, I have prepared, my lord, I'll just read few lines only, but I know I'm running against the time. But please have a look at, my lord. I'm citing only 3 judgments, my lord. One is our court judgment and 2 are, my lord, foreign judgments. One is Balco. Lord, on a lighter side, my lord, to my lord Justice Vishwanathan, light from any quarter is welcome, provided we are in dark. But we have our own very rich jurisprudence, my lord.
No, it's a big debate between Bingham on one side and Posner on another.
Yes.
He says light from all sources. The other says in no circumstances.
Justice Scalia had a beautiful passage.
Yes.
Yes.
Remember that case? In the human rights context.
Yes. But, we are not. So please have a look at. I'm sorry, my lords. Yes, my lord. Your lordships have this, my lord, additional judgments post hearing dated 13/2. My lord, I have marked my pagination, my lord, so that your lordships can. No, I'm sorry, my lord. Kindly take my original compilation, my lord. I missed. I'm going to skip those judgments, but they are already there in my original compilation, my lord.
Yes.
Lord, page 76. Please come to page 76. So this question arose before Singapore, CAI versus CAJ. So please see the last para 239. My learned friend, I'm told.
26.
Read it, Mr. Banerjee read it.
Yeah, yes. But yes, my lord, my learned friend read, my lord, I need not read it, but it says there is no mention of modification, therefore no modification. My lord, please come to page 119. Because the jurisprudence across, my lord, appears to be that unless there is a specific power of modification in the jurisprudence of arbitration law, nothing further can be read into it. My lord, 119 is, my lord, a judgment under the Arbitration Act by a 5-judge bench of this honorable court in case of Balco. The lordship gets, my lord, page 119.
Yes.
My lord, here also, my lord, there was, my lord, as Mr. Datar submitted, that you read some words in section 2, subsection 2. Lord, kindly see, my lord, para 142, it is submitted that this honorable court in Balco rejected the contention that part 1 of the act was also applicable to arbitrations treated in foreign countries on the ground that in such a case, certain words would have to be added to section 2.2. Now, my lord, how the 5-judge bench says that? Please turn the page over, my lord. Page 120. Within, my lord, inverted comma, the first para, your lordship gets. My lord Justice Sanjay Kumar gets. My lord Justice Masih gets.
Yes.
The role of the judiciary is confined to ascertaining from the words that the parliament has approved as expressing its intention, what that intention was and to giving effect to it. where the meaning of the statutory word is plain and unambiguous. It is not for the judges to invent fancied ambiguities as an excuse for failing to give effect to its plain meaning, because they themselves consider that the consequences of doing so would be inexpedient or even unjust or immoral. In controversial matters such as we are involved in the industrial relations, there is a room for differences of opinion as to what is expedient and what is just and what is morally justifiable. Under our constitution, it is Parliament's opinion on these matters that is paramount. In the same judgment, it is further observed, but if this be the case, it is for the Parliament, not for the judiciary, to decide whether any changes should be made to the law as stated in the Act. Then highlighted part, in our opinion, a plain reading of section 2.2 makes it clear that part 1 is limited in its application to arbitrations which take place in India. The court refused to add words as suggested, my lord. Then 82. Another strong reason for rejecting the submission made by the learned counsel for the appellant is that if part 1 were to be applicable to arbitration seated in foreign countries, certain words would have to be added to section 2.2. The section would have to be to provide that this part shall apply where the place of arbitration is in India and to arbitration having its place outside it, out of India. Apart from being contrary to the contextual intent and object of section 2.2, such an interpretation would amount to a drastic and unwarranted rewriting, alteration of the language of section 2.2. As very strongly advocated by Mr. Sorabji, the provisions of Arbitration Act must be construed by their plain language or terms. It is not permissible for the court, while construing a provision, to reconstruct the provision. In other words, the court cannot produce a new jacket while ironing out the creases of the old one. In view of the aforesaid, we are unable to support so and so. Now kindly come to page 122. Same, my lord, I am not reading, my lord, but substantially saying that merely because to achieve one achievable and good goal, it may not be possible to add words into the statute, and plain dictionary meaning in the present case, my lord, set aside, my lord, requires to be taken. Now, my lord, Mr. Khambata's argument, I am not taking individually, but broadly after giving, my lord, the picture, he said that something which is just and proper, if the court exercising powers under 34 feels that something which is just and proper can be done, then why should it not be done? My respectful submission is, my lord, the answer begs the question, my lord. The question is not why it should not be done. The question is, can it be done? And to substantiate or buttress, my lord, that submission, may I assist your lordship, my lord, with section 28.2. The section 28.2. Lord, something may be just, equitable, but still not permissible, even for the tribunal. Kindly have a look at, my lord, section.
That part that calculates a specific contract.
Agreed by the parties. It has to. Lord, the arbitration is an adjudicatory
No,
mechanism.
that means you're bound by the contract. You can't go out of the contract.
Lord, arbitration
And
essential.
you can't go out of the law.
Lord, arbitration, my lord, the sum total of all, my lord, the pleadings. I'm sorry, my lord, Justice Kumar is. My lord, the judgment in interplay between arbitration agreements under the Arbitration Act and the Stamp Act. Lord, para 92. Lord, it is in the compilation at page 182.
Yes.
Lord, I can give, my lord, the citation.
Okay, that's fine.
My lord, this is the ratio, my lord.
Yes.
My lord, I need to say a few more things first. Lord, now, Lord, Mr. Nafde argued about the statutory arbitrations, that they should be placed in a different compartment and different mechanism should be applied. My lord, the clear answer is section 2.4. My lord, please have a look at section 2, subsection 4. It's a clear answer. There are several statutes like, my lord, MSME Act, National Highways Act, etc., my lord, which provides that there would be an arbitration. Arbitration is provided within the act, within that particular respective act. What happens? No, that is 2.4. My lord, kindly have a look at for section 2.4. This part, does your lordship say? This part, except subsection 1 of section 40, section 41 and 43. 40 is when a person dies. 41 is when a person is declared insolvent, and 43 is some similar contingency, shall apply to every arbitration under any other enactment for the time being in force, as if the arbitration were pursuant to an arbitration agreement, and as if that other enactment were an arbitration agreement, except insofar as the provisions of this part are inconsistent with that other enactment. So that act is to be treated as an arbitration agreement, and this entire act applies. In case of National Highways Act, my lord, section 3G, subsection 6 provides for an arbitration. So 2.4 would apply. It would be governed by this act. Section 18.3 of the MSME Act provides for an arbitration and specifically provides that henceforth the provisions of the Arbitration Act. That's what, my lord, incorporation by reference, as we understand. My lord. So last, my lord, and my lord, this is, my lord, according to me and for the government also, my lord, more serious part. My lord, wherever your lordships have seen, there is a power of variation or modification is given. Its contours are fixed, that it can be modified if contingency A, B, and C are met. Correct, my lords? Now, my lord, we are considering, my lord, and we are assisting your lordships whether by way of a judicial pronouncement, your lordships can read into the provisions power of modification. Your lordships will not be able to. Lord, can I continue?
Yes, yes, yes. Oh,
continue, or my lord?
No, continue.
15 minutes tomorrow, whichever way.
So please continue.
Lord, your lordships.
We'll get up at 4:30. Let's.
Lord, your lordships can. Lord, I am not challenging the jurisdiction or the power. If your lordship can trace that power in some provision, your lordships can do that. Hypothetically, my lord, I presume your lordships have read that power into something. Your lordships will not be able to define under what circumstances that power will be exercised, that you can modify. This is why you will have to apply the doctrine of severance. This is how you can modify. This is the extent to which you can modify. And that judgment conferring power of modification will be used by every district court in the country, by 25 high courts in the country, and in many of the high courts, my lord, we, the lawyers, my lord, are not that equipped, my lord, in commercial litigation. I leave it at that. How that judgment, my lord, would be used before the courts, variety of views, variance in views, ultimately, my lord, leading to appeals being filed on both sides.
I will not be able to take the second part of your argument.
Look, this is my respectful submission.
I'm sorry.
Look, therefore, my lord, no.
As far as that is concerned, I can't take it.
No, your lordships need not take that, my lord. But, my lord, the purpose of my saying is, if it is a statutory provision, it will have its contours defined by the statute.
We understand, but then the law is just like we don't have any sentence policy, so we leave it to the court. The legislation, there is always when the legislation is passed, there's an element of discretion which is always left to the court. And when we excise that discretion, we are not overstepping ourselves.
Yes. Lord, I'll not cite.
We know when we legislate and when we step into to only deal with issues which have been left by the legislature to us. Like the Constitution has left it to us to interpret the words of the legislature.
Correct. Lord, for example, your lordships have seen Singapore, US, and England. They have statutory carved out powers.
You're right. You're right.
So there would be some limits, some, my lord, four corners defined by the statute, which would not be possible for your lordships, my lord, to envisage and carve out, my lord, leaving it open for every court to
We
have
are
its
conscious
own.
of that. We are conscious of that. We can't have an open-ended thing.
That's the problem.
Or forget about open-ended. It has to be in consonance with the objective behind 34, limited court interference, if we accept the argument of the other side. It has to be within the four corners of 34, the object and purpose and the contours of 34. The court is not an appellate court, but only a court which is working within the strict confines of what is provided for in 34.
Lord, in that scenario, my lord, when your lordships are seeking to trace, as my lord, the other side is requesting, the power of modification under section 34. My lord, the section dictionary meaning and linguistic meaning says power to set aside. My lord, please allow me to, I'm not reading it. My lord, I have compiled the judgment of the meaning of the word set aside. And my lord, I have, Lord, just for your lordship's quick reference, Lord, the relevant para of how the courts have read to mean set aside. And that is, my lord, set aside means annulled, something which does not cease to exist. So, my lord, it may perhaps be very difficult for your lordships to.
That was pointed out by Mr. Kripal and Mr. Banerjee.
Yes, my lord, but these are the judgments on the point. These are the judgments on the point, not only of India, but of other jurisdictions, that power to set aside means power to annul, power to nullify, power to evaporate.
Any of the judgments specifically saying power of setting aside will not include the power to modify, one. Number two, or even correct arithmetical clerical errors or calculation mistakes.
That 33 is there. Your lordships need not invoke 34 for that. But only one judgment, it's a Jammu and
33 is with the arbitral tribunal. 24 is with the court.
Correct. My lord, please see one judgment only, only one part of the judgment. That is, my lord, Jammu and Kashmir. It's a recently delivered judgment, my lord, a week before. But it takes, no, my lord, your lordships you can have this one. It's a, yes. I have just given, my lord,
more attractive.
Yeah, yes, my lord. Lord, this is the only way we can make this argument attractive, my lord. Otherwise, it's a very boring subject. Lord, kindly see the yellow highlight. Lord, I'll read para 61. If we have a look at the judgments rendered by the Supreme Court in N. Hakim's case, Larsen Engineering, so and so, what the Supreme Court has held is that court, while considering a petition under section 34, does not have jurisdiction to modify the award. The question that poses itself before this court is whether a part of the award which is not in consonance with law can be set aside, leaving the other part of the award which are in consonance with law untouched. It has to be borne in mind that there is a lot of difference between the terms modification.
First part is contrary to what you are also accepting, and what is the other side?
Now, what is setting aside? I am relying upon for setting aside. Now, kindly read the yellow part. Modification and setting aside. While modification means changing or altering something with a view to improving it, whereas setting aside means annulling or making invalid. Thus, the basic difference between modification and setting aside is that while modifying an award, it is sought to be improved by keeping its base intact, etc., etc. Then, my lord, there are some other judgments also, which takes the view, my lord, the view appears to be consistent, that setting aside means complete, not midway, modification, variation, etc., etc. And setting aside an award, what is setting aside an award, put in line, my lord, it could not be. Whereas the setting aside means the award is annulled. So that's the, and my lord, in the compilation which I handed over, my lord, there is one chart, your lordships may need it, my lord, when your lordship decides. The countries which have consciously accepted and adopted unilateral model, and my lord, I have given the country's name and the relevant provision, which is peri materia to 34. Lord, your lordship, lastly, your lordships, my lord, put a question to my learned friend, that the very fact that we inserted public policy under 2A would mean that there is a deviation from the unicitral model law. But my respectful submission is that unicitral model law is ultimately a model to be treated as a guide.
He said that only for the reason when he said our awards will not be amenable or will not be acceptable abroad. Two, also to the extent that it was said that we should blindly follow the unicitral commentary rather than apply our own jurisprudence.
Lord, one last thing, Lord, which we all of us,
With which you agree, I think.
Lord, all of us missed. Lord, please see para 4 of statement of objection reasons.
He have said that. We quite.
No, only, Lord, for my, Lord, it says one of the ground is to ensure, Lord, para 4, main objectives of the bill are to minimize the supervisory role of courts in arbitral process. Now, Lord, the exercise which all of us are undertaking before your lordships is, Lord, they are saying that optimize it. And we are saying, please restrict it to the statement of object and reasons as envisaged by the Parliament. It's one of the objects.
Second round will be avoided. So we are minimizing actually.
Yeah. And what is minimized?
Lord, your lordships will have several rounds if it is expanded.
Okay. Yes, President.
No, I think she wants to argue. No, then we'll get you.
No, Lord, my learned friend wanted to give one illustration in 2-3 minutes, already. And my
If for a moment, if it's to be assumed that the setting aside power subsumes the power of modification, all the examples are given in the context of interest. But we should be also mindful of the fact that certain situations, the determination of interest and period also requires adjudication. The classic example is application of MSME interest. In a given case, without referring the SLP number, the arbitral tribunal holds that the MSME interest cannot be applied to this particular claimant. In section 34, district court comes up with a 56 paragraphs of judgment saying that arbitral award that partly is against the fundamental policy of Indian law and substitutes own view to say why it applies and for the period how it applies. So to that extent, the modification cannot be permitted. And also, your lordship, introducing guidelines by judicial interpretation may open a floodgate. We have already argued that. Just like a public policy, we certainly don't want another unruly horse. So lastly, my submission is that the supervisory jurisdiction under section 34, your lordship, it should be confining to intervention. It should not amount to interference. That's it. Great.
It's just 5 minutes because everything is covered, and I would just like to sum up, my lords, in furtherance to what learned Solicitor General has also argued. Let's setting aside an award, it includes partial set aside. Though the word partial is not particularly mentioned in the Act, but the doctrine of severability is ingrained very intrinsically in the 1996 Act. Well, at section 21C, if one looks at the definition, my lords, section 21C says arbitral award includes an interim award. And that means, my lords, the judgment of IFCO versus Bhadra also is on the point. Then the question is where, if it's the interim award, then it will be challenged in the 34. Whether it would come under 16 and 17, I'm not taking my lords in that, the entire judgment. But that is a judgment on point which says that there can be an interim award. So therefore, doctrine of severability is ingrained. Well, there is no qualm about it. Next, my lords, when we talk about the modification, section 34(1) is very clear. It says set aside, but 34(4) uses the word appropriate. Now, when my lords decide, and of course, 34(4) says that you have to remit it back. Now, remit back also, but the word uses appropriate. What is the meaning of the word appropriate? That has to be looked at after going into the facts of the case when my lords are satisfied. Otherwise, my lords, we have seen in so many examples that under 142, this court takes a call. So, for example, in the interest rates, etc., that instead of sending it back, because the statute does not say that you can modify, but instead of sending it back, to be able to save cost and to be able to do what the act purports to do, this court under 142 has even done difference in the rates of interest, etc. Well, that is my second point. And well, 31(6) also talks about, if I can just, that's the form and contents of arbitral award, that says the arbitral tribunal may at any time during the arbitral proceedings make an interim award on any matter with respect to which it may make a final arbitral award. Well, it's in my most humble submission, my lords, modification though is not provided in the statute, but sometimes, my lords, some supervision of the courts is necessary to finally give finality to the list and also the objects and reasons, to keep in mind the objects and reasons of the act. I'm grateful.
Corrective modification is permissible.
It's not, my lords. It's not permissible. It's not.
Only one.
Last part was to the contrary.
Only two minutes. But I tried to play devil's advocate. And if your lordships really wishes to trace it, but possibly this can be one way, but it would be doing violence to the language, my lord. Kindly have a look at, my lord, subsection 4. Kindly, my lord, I could not finish the handwritten part, my lord. So one.
Subsection 4 of 34.
34.
Yes.
We can share.
No, kindly have a look at this.
Can we have a copy?
I'll just give you. It's the 34-4.
I want in color, yeah.
Yes. On receipt of an application under subsection 1, meaning thereby praying for setting aside, the court may, discretion, where it is appropriate and it is so requested by a party. Again, my lord, discretion because appropriate. Adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings. This is first part, that you remit it to the arbitral tribunal. Second part, possibly if your lordship reads disjunctively, or to take such other action. But such other action can be by the tribunal or by 34 court itself, as in the opinion of the tribunal. Now your lordships will have to read opinion of the tribunal means expressed in the award. As in the opinion of the tribunal will eliminate the grounds for setting aside them. Meaning thereby, if
How can that be available to the 34 court? It says or to take such other action as in the opinion of arbitral tribunal. So that such action has also to be in the opinion of the arbitral tribunal.
in the impugn award, if your lordship reads, that impugn award
It has
has
to be post the reference by the, after the reference, after.
Resume the proceedings or takes.
I know that it's the original section. I am not adding words. I am not adding words like you.
So you left it to the court to add words.
No, I'm saying if
We have understood. Yes,
phrase after or can be used disjunctively. And it would be not doing violence to the language, but this is the maximum I could stretch.
Yes, please.
Yes, to leave one shot. Can we?
I'm just not to borrow them. We have to finish.
All right, little bit more time. Lord Rushland return, come back in the.
Pardon? No, continue.
All right. Yeah, please continue.
May I have 5 minutes?
Yes,
before
please,
my
right.
response? No, just to answer the last point raised by Mr.
Look, the one answer we require is that as far as international arbitration is concerned, if we interfere, then the consequence will be that the awards may become non-enforceable abroad, taking it as a degree of the court or judgment of the court rather than the award itself.
That's exactly the only point on which I wish to address my response. Not the first answer to that is that several countries have power to vary, as my Lord the Chief Justice put to Mr. Banerjee. It's not that the power to vary has scared away or driven away any international commercial arbitration from those countries. They are the leading jurisdictions, England, Singapore, etc. Mr. Panchanda raised another point that if there is no merger, then there might be confusion as to which award is to be enforced. Now, the doctrine of merger including as enunciated in Kunya Mambat, is not a rigid doctrine. It depends on the circumstances. If your lordships were to hold that in the case of a modification, that modification merges into the award, that is all that is required to say that is the award. And I ask myself only two questions. If my learned friend's enunciation that which is the award to be enforced is correct, then what happens to all the awards which have been modified by your lordships under Article 142, even in small ways, including Sangyong, for example, where the minority award is accepted by the Supreme Court? Are all those unenforceable under the New York Convention? How can that ever be? The second area, and here we have unanimity of opinion on both sides, that the doctrine of severability in its broadest form is accepted under Section 34. Every one of my learned friends has accepted that. And they have accepted it as a general doctrine, not only to the limited extent of 34(2)(a) for the proviso, which is whether it's within the reference or not. If the general doctrine applies and an award made on, say, 5 claims, one claim is severed, the award on one claim is severed, it's certainly not the same award. It's a modified award, even to that limited extent. How is that modified award then going to be enforced if it's in an international commercial arbitration? If, according to my learned friends, only the original award can be enforced. So these are examples to show that it is obvious that if a court modifies, and that includes severs, under 34, there is an operation of the doctrine of merger. And that your lordships may clarify, which I think is a good suggestion from Mr. Panchananda, that may be clarified. That's the first point. The second point, and I leave it to your lordship, because these are only submissions. If the power of modification is restricted to 2A, patent illegality, then this issue doesn't arise at all. Because patent illegality is a ground available only in respect of domestic awards, not in respect of international commercial arbitration awards, even if they are seated in India. So if it is restricted to a question of law, which arises inevitably from setting aside part of the award on the ground of patent illegality, then that modification does not run this gauntlet of Article 5 of the New York Convention. Because that award is a domestic award.
If there is a patent illegality,
yes,
then would it be appropriate to modify it? Then the only option would be to set it aside. Illegality.
No, not if it is in a severable portion. If it is a portion where just by modifying the question of law, my law, if the 34 court holds there's a patent illegality on the face of the award, this is not the correct position in law. The wrong article under the Limitation Act, or a section that patently doesn't apply. If the court, to find that patent illegality, will have to decide what the correct section is or what the correct law is. All we were suggesting is that correct law be incorporated by merger into the award, and then only consequential changes. All this strictly under the discipline of 34, no reappreciation of evidence, no going into merits. Therefore, no revisiting the factual record in any manner.
How do we restrict it to a subsection? This power, how do we restrict this to a subsection?
I'll tell my lord.
For example, the just immediate previous subsection.
Yes,
basic notions of morality.
Yes.
Suppose the court is almost concluding that, it is opposed and just wants to save it if there is a fine tuning without affecting the integrality. But on what principle of law do we confine it only to 2A?
Not. The reason why I suggested only 2A is that it becomes a grayer area if you go into public policy or those basic notions of morality or justice. But my lords, in that sense, in principle, are absolutely correct. There is no reason to confine it. But if the doctrine of merger is applied, then if by applying the correct position, one that does not offend basic notions of morality or justice, then that becomes the award. So no problems of enforcement will arise whatsoever, if that is clarified.
This is only a ground.
It is more
Power actually set aside in two.
Yes.
And an exception is carved out saying patent illegality will not apply to international commercial arbitration.
Yes.
It's actually a restriction on the otherwise sweeping power of 34(2).
That is
to be source the power here, confine it to this subclause.
In this sense, that the power to modify, if it is not to involve a power to reappreciate evidence or to go into any factual matters, because if that is the discipline of 34, that discipline must be adhered to. If that is so, then it is only on a question of law that your lordships can contemplate that not only is that part severed, but it is replaced with the correct position. It therefore enables a modifying court to keep within the discipline of 34. The moment one goes into notions of morality or justice, there is much more play in the joints there.
Was there any particular reason why you said that it will be only confined to 2A when you argued?
Because that
international application is avoided.
But that part.
Patent illegality was not part of international. So
Correct,
domestic-
but that's why you argued,
No, I can't claim credit for the prescience my learned friends gave me. But that is one of the ways in which the argument raised by my learned friends can be met.
But if it 18% interest may not be patently illegal, but the court may feel the interest of justice.
I bow to
is
that.
12%.
I bow to that, and that is why perhaps some more power of modification is necessary, but with the strict caveat, no reappreciation of evidence and no going into the merits of the decision. If that caveat is there, then anything that is outside of that is permissible. And that should be a sufficient safeguard even for subsection 2. Therefore, my lord, this anxiety is really more alarmist here. And
Quickly, I'll run through. First, my point is the argument that if you tinker with 34, somehow our awards will lose efficacy in international forum is completely misplaced. But my submission is this. They say, let Parliament make a new section, then there is no problem, like Singapore.
because what they say is deemed to be part or deemed to be an award.
Yes.
Because because of the deeming friction.
Yes.
Yes, you can argue before the foreign court, you can say domestic award cannot, but then it will only happen if the seat of arbitration in India, you've held that the law of arbitration will be applicable.
I'll put it this way. In the International Arbitration Act 1994 of Singapore, there is a provision where international commercial arbitrations can be changed.
The answer to that can be very simple. The law of arbitration in India is applicable as interpreted by the Supreme Court.
I'm about to say that because Article 141, Lord, what is the law applicable in India is the statutory provision as interpreted by the Supreme Court. It is X plus Y. So if Parliament is not making a law today, we can't simply fold our hands and say, sorry.
No, please. If you go in that direction, you will be falling in the trap.
No.
What you can argue is it's already there.
No, I'm saying it is there. What I'm saying is, suppose the Supreme Court said setting aside includes partially setting aside, then that is not making our awards unenforceable. What your lordship is saying is, as far as we are concerned, we have to make 34 efficacious. We have to make 34 proper. Therefore, my first submission is, if your lordship makes set aside to mean partially set aside, and when your lordship partially sets aside the award, actually is modifying the award, whether you like it or not, the net result is, award was ABCD, now it's only ABC. So it's a modified award. So my submission is by just doing is not possible. Secondly, my submission is, please follow your lordship's own judgments. They follow the dictum of learned hand, who said, don't make a fortress out of a dictionary. The famous statement of judgment followed in 26 Supreme Court judgments, that Cabell versus Maxim. In state of Tamil Nadu versus Kodaikanal, I'll give the citation, it's in my note here. The division bench of the Supreme Court says, they refer to Lord Denning, that C4 ironing out the creases. Then they refer to learned hands paragraph and says, if there is practical difficulty, even some violence to the section is permissible. It is 86 Supreme Court. I'll give your lordship the citation, or I'll give it in a note tomorrow because it's no time now. So what I'm submitting is, when I said, please add the word to the extent of. Pardon me? No, the 26 judgments, I have it right here. This is my note. I was working on it. I don't know now. It's
in the
suddenly.
note.
Is there the cases where it was impossible to reconcile?
No, I'm saying
Not to create a remedy.
no, there it was off and the Supreme Court. I'll give the state of Tamil Nadu versus Kodaikanal. I'll just give the citation. Just see my note here. Just to see this. I've made a note of it. So, Milord, my submission is it is also in KP Varghese, para 5. Lordship will take KP Varghese, 1981 3 SCC, and also in state of Tamil Nadu versus Kodaikanal matter, where the court held that you can do violence to the language to make it to save the provisions. Now, Lordship will kindly see.
We are not saving the provision here. We are not
To make it workable.
We are not saving that.
Yeah, to make it
KP
workable.
Varghese was with that income tax matter.
Yes, it's to make it workable. Now, Lordship will kindly see, one sec, I'll just give it. Just 1 second. I'll give the citation now itself. Yes, yes.
That may not help you.
Yes. No, Lordship will kindly see 1986 3 SCC, page 91.
1986.
3 SCC, page 91, para 16 and 17. And KP Varghese, 1981 4 SCC, 173, para 5.
The para, 1981.
4 SCC, 173, para 5. Where both section 52(2) of the Gift Tax Act was read down, slightly modified to make it workable. In this earlier case, a Tamil Nadu provision.
Workable. It's not that it's not workable, but at least for in your what has been what's bothering us is
What I gave the suggestion.
It's not a solution to a problem. It's creating more problem. It's
No, my humble
they feel by doing
Yeah,
it,
that's
we'll
what
be
they are
creating
saying.
more problem.
Well, my submission is, I'll just stop because others have to argue. If you add the words to the extent of, which I just made those 3 words, it gives a guidance to the lower courts, the district court, the high court, and so on and so forth, that if there is a patent illegality, to the extent of patent illegality, you can partially set aside, modify whatever you deem fit you do. So my humble submission is, if your lordship reads set aside to mean partial set aside, or adds the word which I have suggested, it will not make our awards unenforceable. This will be the section 34, which will make it workable, which will make it practical, both for international commercial arbitrations and domestic commercial arbitration. And what I'm submitting is section 5. Now, please see section 5, just 2 points. On section 5, and I'll also read the other provision. Please see section 5.
Quoted
Yes.
for us.
No,
it
it
says.
says,
Explain the contours of it.
yes, it says, except where so provided by this part. So provided can
If
mean
we
a
can
section
include
30.
it in the part, then it will not be violating section 5.
No, yes, if a lordship takes section except where so provided, will mean except as per section 34. And that section 34, after this, if your lordship accepts our contention, when so provided by the part, will mean so provided of section 34, including partial set aside. So I'm saying that section 5 is not a bar. It doesn't say keep your hands off. It says you can judicially intervene except as so provided. Then, Lord, the question of section 9 of CPC, Lordship will kindly see, as just Vishwanathan pointed out, what does 9 say? It says nothing in the code. It's a non-obstante clause. It says the inherent power of the code will not be taken away by anything in the code itself. But number of other judgments have said, when a civil court is acting under other jurisdictions, their power will be circumscribed by the other acts. So section 9 is a non-obstante clause only where the CPC itself. But when your lordship says principal civil court, that principal civil court will have inherent
The
powers.
difficulty, we completely say CPC is not applicable. It lead to huge, if one sentence of this nature, yes, where the appellate remedies are provided for, you cannot, therefore by implication, other appellate remedies in form of revision is then taken away in the.
Or I'll put it this way, the inherent civil court cannot alter that particular process.
Expressly or impliedly can be taken.
Not the other point which I wanted to mention here is this question of section 34(4), and I give my chart, those things. What I'm submitting is 34(4), the word appropriateness, as my friend also pointed out. The court comes across a case where there's a ground to set aside the award. Now there is a request by the party to send it back. Now sending it back, the court then has to apply its mind. Yes, there is a ground to set it aside. Will it be appropriate to send it back? Or the court can come to a conclusion. instead of sending it back to the tribunal, which the court may have various factors, the arbitrator may not be available, it was various reasons maybe there. The court may say, yes, there is a ground to set aside. But in the facts and circumstances, it is not appropriate to send it back. Let us see if we can partially set aside to that extent, or we can slightly tweak it. That's last submission I'm making, answer to Mr. Gaurav Banerjee's statement that the moment you vary the award, there is an award and there is a judgment, only the award. I'm looking at a case where the award, the contractual rate is 18%. The arbitrator gives 12%. Suppose the court makes it in conformity with the contract. Will it become unenforceable? I don't think that can be the argument at all. Suppose now it's an arbitration in India. Substantive law of India has to be applied. Then what happens? Then suppose the arbitrator has made a mistake and the court only brings it in conformity with the contract. Then I don't think that will be a ground to say you can't vary at all. It has to go back. That's it.
Well, it's just,
That's all.
just 2 minutes, one line point.
Yeah, that's a lot.
Arbitral award includes interim award. It will also include an arbitral award which is partially set aside. The award ultimately will be as set aside by as done by the court. And case after case, the Lordship has done. Lordship has made changes to the award. Lordship has made changes under 142. What is being done under 142 can be done by all the courts. If your Lordship says it can be partially set aside, just my humble request is the parameters of 34 can be seen and keep it confined to that and that alone.
Let's say the argument on a lighter side, severance of the award is not restricted. You can sever the section also. Apply it only to 2A.
But just one line submissions, my lords. One is that it's not UNCITRAL model, not binding, my lords. It says consideration and with appropriate modifications. The fact that other legislations have appropriately modified cannot really determine what happens here. Here, there may not have been a need for modification, my lords. The section as it stands, it's a question of interpretation and discovery. So, my lords, that is the first part as far as modification part is concerned. Then second part, my lords, is that clearly what is restricted is the manner in which the party can challenge an award, which is by way of setting aside, an application for setting aside. That does not trammel or restrict the court's discretion, my lords, to make suitable modifications to the award. Because the principle of law is well established, and I'll just give that citation, my lords, 2016 9 SCC 426, that when a discretion is given under a statute, 2016 9 SCC 426, my lords, I'll just read it out, para 16. Discretion assumes the freedom to choose among several lawful alternatives. Sorry, my lords, I'm sorry, that's not the one. 2004 8 SCC 307. 2004 8 SCC 307, para 6. The word discretion connotes necessarily an act of a judicial character, and as used with reference to discretion exercised judicially, it implies the absence of a hard and fast rule.
You need not go that far. The
Yeah.
answer is simple. As if we have to accept it, power of interpretation rests with the court.
Absolutely. And fair, what is fair and just and determinable, my lords? Then, my lords, one part, just last point, my lords. Mr. Banerjee,
Page number of the previous citation.
my lords, that is, the citation was, my lords, I'll just
2004 8 SCC.
2004 8 SCC 307, para 6. It uses the word fair and just determination, sound, fair and just determination, the moment a discretion is given. So the power arises from the power of discretion, not from the setting aside provisions which are coming out. That's the point which I was making.
Okay.
And my lords, one last point. As far as what Mr. Kirpan had argued, that everything is going well, there's no problem, my lords. It's only confined to commercial cases. If you look at the other cases.
This is observation.
Yes, absolutely.
We are grateful to
Grateful, I'm deeply
grateful for a patient hearing.